indulgence, Judge. On the record, today is the 28th of April 2022. CC 67 of 20, Sidia and 4 others.
As the court pleases, my lord, before we went on record, I intimated that the state would like to object to the current line of cross-examination.
I just want to intone and to comment that you could have sent, via the secretary, you could have sent this earlier so that
Yes.
I don't have to read word for word.
Yes, my apologies, I'll take the court through that, my lord.
All right, okay.
Yes. My lord, we've filed brief heads of argument, and the heading is objection against the current line of cross-examination. My lord, the state objects against the current line of cross-examination that traverses issues.
Oh,
I do not need to address the court.
is it on the same issue? Is it on the same issue?
Yes.
Good morning, my lord. The state has a tendency of us giving us documents in court, which is tantamount to ambush. He prepared the heads. They prepared the heads. We never prepared heads. Therefore, the best thing is that the matter be postponed.
No.
For us to prepare the heads. There's no way we'll respond to the heads which are prepared. And we are not prepared for those heads, my lord.
Advocate Baloyi?
Unless they take them out, we cannot respond.
My lord, the heads were finalized this morning. It's fine, we'll go through the heads, and if they need time, my lord, we will not have any issues for them to go and prepare their heads, my lord.
So that whatever, if there's a ruling to be made,
Yes.
it will be after they will have.
Indeed, my lord.
Okay,
Yes,
let's
thank you.
proceed.
My lord, as indicated, the state objects against the current line of cross-examination that traverses issues that Sergeant Musia did not testify about, and the main grounds of objection are the following, my lord. Firstly, we submit that such cross-examination is irrelevant, as Sergeant Musia is called upon to express an opinion on matters that he has no knowledge of. And secondly, my lord, such cross-examination will not, in our submission, assist the court in its eventual decision on credibility. We deal briefly with each of these grounds, my lord. Firstly, as far as the irrelevance of cross-examination is concerned, my lord, we make the following submissions. Sergeant Musia described his duties when he commenced testifying that he is a forensic field investigator. He collects, packages forensic exhibits on a crime scene, and dispatches.
Can I just interject to say that just with the sentence you read,
Yes.
I think under cross-examination he also added that he considers himself an expert.
Yes, in the field, in that field.
Yes.
Yes.
Okay.
He collects packages, forensic exhibits on a crime scene, and dispatches or hand those forensic exhibits found on the crime scene to the forensic science laboratory for analysis, as he has done in this case. And my lord, that is where his role ends. He has special knowledge or experience in processing exhibits on a crime scene. And my lord, in our submission, there's nothing wrong in cross-examining him on whether he followed the right standard operating procedures in processing a crime scene, or asking him questions that show that the exhibit might have been contaminated when he processed them. Or, for instance, my lord, that they were not properly marked. And in our submission, my lord, this is the reason why he carefully documented the process, and photos were also taken to demonstrate that he followed the correct procedure. And as the court has just pointed out now, he is an expert in the field of forensic work and can give an opinion on that because he's qualified by virtue of his special knowledge and experience. And in our submission, my lord, questions will also be permissible as to whether Sergeant Musia is properly qualified to give expert evidence on the collection, the marking, and dispatching of exhibits, and whether he is so qualified in the field of forensic field, collection of exhibits on crime scenes, to the extent that his evidence is receivable, and whether his knowledge and experience are sufficient to justify the court in accepting his views on the specific matters to which his testimony relates. And my lord, here the emphasis falls on to which his testimony relates. And in our submission, my lord, questions such as the training that he has undergone, the courses that he attended, those, my lord, we submit, those will be relevant questions. My lord, we make the point that the primary purpose of cross-examination is to elicit information from a witness which will be helpful to counsel's case or to the cross-examiner's case. And, we referred to the locus classicus on cross-examination is the work by a well-known author, Coleman G., on cross-examination, a practical handbook, the 1984 edition, and we refer to page 5 thereof. And he describes cross-examination as, and we quote, a process designed to expose the witness who's deliberately lying, that a witness has been mistaken, or that is biased, or otherwise unworthy of credence, or that material points have been omitted or inadequately stressed in the evidence in chief, or raise doubt about the reliability of the witness, or the accuracy of his evidence on a material point, and we close quotations. My lord, we submit that the current line of cross-examination does not seek to achieve any of these objectives. Sergeant Musia is asked about what the state witnesses will come and testify about. And once again, we quote from the work of G. Coleman, wherein he says, and we quote, material that may be used in cross-examination includes oral evidence which others have given or will give, and which, if accepted, may discredit the witness, or otherwise destroy or weaken the effect of what he has said. And here, my lord, the emphasis falls on what he has said, in other words, his version. The search is for weaknesses in the version given by the witness. And once more, my Lord, we emphasize the version given by the witness, or in the character or reliability of the witness himself. We close quotations, and that can be found on pages 40 to 42. My Lord, we submit that a witness must have testified about a certain point to be confronted about what other witnesses will say. In other words, if a witness says, this is, what I observed, we submit, my Lord, that the cross-examination can then be directed at that particular point to say, on what you are saying, there'll be other witnesses who differ with you on that specific aspect. My Lord, Musia has repeatedly testified that he's being asked questions about other witnesses that he knows nothing about, and that he's not testified about, my Lord. We submit that if a witness testifies about a certain point, it is permissible to confront that witness about what other witnesses will say on that specific point that the witness is testifying about. And my Lord, we underline, that portion. Sergeant Musia has been confronted with versions of witnesses whom he knows nothing about and has not testified about their version in evidence in chief, and who may or may not be called as witnesses. And for instance, my Lord, it was put to him by counsel for accused number 1 to 4 that he has been informed that DNA profile found on the head is that of a woman. My Lord, no DNA report has been shown to Sergeant Musia.
But is that irrelevant? Is that not?
Yes.
Is that also not central to
Yes.
what Sergeant Musia is about? Because whatever gender of the DNA, the state would maintain that it was DNA collected by Sergeant Musia.
No, all we are saying, my Lord, is that it's fair for counsel to say, listen, I'm in possession of a DNA report, of which the profile shows that the DNA profile obtained on the head is the following. But then merely, my Lord, to say, I am informed.
Okay.
And we'll just demonstrate, my Lord, just now the danger of that line of cross-examination. My Lord, we make the point that speaking generally, a cross-examiner should put particulars of the material to a witness to allow that witness to respond to the question. My Lord, we have handed in DNA reports as Exhibit B, in brackets 6, and B in bracket 7. And no reference was made by my learned friends to those exhibit in putting that question. And my Lord, I want to be very careful not to testify from the bar as it's improper, but I, on the 4th of April, requested the analysts to provide us with the DNA profile on the head. And He's still working on that, my lord. And the information that was conveyed to me, my lord, is completely contrary to this question that was put to the witness. And perhaps maybe it's in the interest of justice that I should state that, you know, if it's necessary, the state will, as soon as I've received that report, yes,
I hear the testimony from the bar here.
yes, yes,
I think you
yes.
you even announced it.
Yes.
Please don't testify from the bar.
All I'm saying is that, my lord, is that as soon as that report is complete, we will hand it up, and that will contradict what was put to the witness. And, my lord, this underscores the danger that counsel confronts a witness about, as counsel has put it, what he's been informed, you know, without producing a scrap of paper to say, I'm in possession of the report, here's the DNA profile on the head, and it says the following. We submit, my lord, that once again, that underscores the importance, my lord, of counsel not putting to a witness something that he has not testified about. If we call someone from the forensic science laboratory and the person comes and say, I hold a BSc degree in chemistry, I'm attached to the forensic science lab, I've received the exhibit in this case, it's a head, I've obtained a DNA profile on this head, I've analyzed it, and I've looked at all the loci on this particular DNA profile, and the readings are as follows. Then, my lord, we submit that that will be the relevant person to confront with this with this evidence. Otherwise, my lord, if counsel is just asked to, if counsel just cross-examines on general issues, we submit, my lord, that incorrect questions will be put to the witness. We submit, my lord, that over and above the fact that such a question cannot be put to Sergeant Musia, Musia as that follows the ambit of his evidence in chief. As we've already demonstrated, my lord, the question was put with such vagueness and lack of particularity that it should be impermissible. Now, my lord, we deal with opinion evidence, and once again we quote Coleman at page 104, where he describes an expert witness as, and we quote, a witness whose opinion on some matter is receivable in evidence because it is a matter upon which he is qualified by virtue of his special knowledge or experience to draw inferences and form views which the court cannot draw or express without the assistance of a person learned or experienced in the relevant field. And we close quotation, my lord. We submit that, generally speaking, opinion evidence refers to direct evidence outlining what the expert witness believes or infers in regards to the facts, as distinguished from personal knowledge of the facts themselves. In terms of our law, a witness is supposed to testify as to what was observed and not give an opinion on what was observed. Or differently put, my lord, opinion evidence is an inference, impression, conclusion, or belief that an expert witness gives in support or opposition of an issue to be proved in court, And expert evidence is often used to assist courts where the issues to be determined are of a scientific or complex nature, as is often happens with, for example, chemistry, ballistics, psychiatry, etc. And courts have always said that they will not simply admit evidence because the person testifying is an expert in the field. And here, my lord, we refer to the case of Holthausen versus Ruot, it's 1997, volume 4, SA 766, where the court held that the courts have developed various principles to aid in determining whether expert evidence is admissible in a particular case. And the following principles were formulated. The expert witness must be called to give evidence on matters calling for specialized skill or knowledge. And my lord, the reason thereof is simply this, that the court should be able to rely on the opinion of that expert. And if someone is not sufficiently qualified, and as it's sometimes put, that person is an amateur in a specific field, it will be unsafe to hear, such evidence, or even to, to rely thereon. And secondly, the expertise of the witness should not be overstated to such an extent that the court's own capabilities and responsibilities are disregarded. Thirdly, the witness must be a qualified expert with sufficient skill or expertise. And fourthly, the facts upon which the expert opinion is based must be proved by admissible evidence and must not be based on hypothetical scenarios. We've had
Sorry about
yes. My lord, we've heard, for instance, when Sergeant Musia was asked about the cartridges, and he said he thinks that a revolver was used, but that shows that he's speculating, and we submit, my lord, that shows the danger that my learned friend is currently eliciting. And fifthly, the guidance offered by the expert must be sufficiently relevant to the matter in issue, which is to be determined by the court. And lastly, opinion evidence must not usurp the function of the court. A witness should not be permitted to give an opinion on legal matters and must not be called to answer questions which the court has to decide. This is sometimes referred to as the ultimate issue doctrine. My lord, we make the submission that a trial is conducted according to the rules of criminal procedure and law of evidence. We further make the point that the rules regulating admissibility of evidence serve to help our courts to only focus on facts upon which the success of a party depends in law, as we've explained, my lord, relevance. The court should uphold the fairness and integrity of the trial by ensuring that parties are not unfairly prejudiced by having to defend themselves against irrelevant evidence adduced against them. My Lord, the courts have held that fairness is a double-edged sword. There must be fairness not only to the accused, but to the state as well. And here, my Lord, we refer to the locus classicus of State versus Sheikh and others. The reference is there, where the court held as follows, from paragraph 49, and we quote, "The applicant stressed that they place their reliance on the general right to a fair trial, which, as this court has held, extends beyond those specific rights enumerated in subsection 35(3) of the Constitution. The right to a fair trial requires a substantive rather than a formal or textual approach. It is clear also that fairness is not a one-way street, conferring an unlimited right on an accused to demand the most favorable possible treatment. A fair trial also requires fairness to the public as represented by the state. It has to instill confidence in the criminal justice system with the public, including those close to the accused, as well as those distressed by the audacity and horror of the crime, with close quotations. My Lord, the state has made it abundantly clear during the Section 150 address that ballistic evidence is a crucial aspect in this case. We submit, therefore, my Lord, that the only reliable and credible evidence of a ballistic expert should be permissible. And counsel for accused number 5 has asked Sergeant Musia the following question, which, in our view, and any question of a ballistic nature should not be permissible, as Sergeant Musia is not a ballistic expert. And we quote this question that was put to Sergeant Musia. If someone says accused number 3 came in the house with a 9mm parabellum and shot the deceased, since no cartridges were found on the scene, how do you explain? We close quotations. Sergeant Musia then answered by speculating that a revolver could have been used. We submit, my Lord, that this line of cross-examination will not assist the court in its eventual decision on credibility. We respectfully submit that there is danger inherent in allowing such cross-examination, in that speculative evidence will be elevated by the defense to facts and seek to show a discrepancy with the ballistic expert, or be used to confront other witnesses with such evidence, when such evidence should not have been allowed to start with. Such evidence might also cause confusion as to its status, and thus become a red herring. Such evidence is prone to mislead, my Lord. We therefore submit that such cross-examination be disallowed, and any opinion evidence regarding ballistic evidence and DNA evidence that has already been given in this regard be struck off the record, or be regarded as pro non scripto. We indicated, my Lord, during the Section 150 address that a ballistic expert, and possibly two, will be called, and Such questions, my lord, can then be put to him or to them. We refer to the case of S versus Tele, it's 1965, volume 1, SA 82. The appellate division it was then, now the Supreme Court of Appeal at page 91H. The court held the following, and we quote, "Latitude in testing by cross-examination the credibility of a witness where credibility is clearly the issue should be allowed until the court is satisfied either that the right to cross-examination is being abused or misused, or that the particular line of cross-examination could never be productive of anything which could assist the court in its eventual decision on credibility," we close quotation. My lord, we submit that the current cross-examination of Sergeant Musia on issues which he did not testify about and fall outside his knowledge, experience, and expertise should be disallowed, as such issues will not assist the court in its eventual decision on credibility. We also submit that fairness requires that such evidence be excluded, and the courts have held that fairness is an issue that has to be decided on the facts of its case, and that the trial judge is best placed to take the decision. We refer to the case of Ferreira versus Levine. The quotation it's given there. We therefore, my lord, object against the current line of cross-examination. We submit that Sergeant Musia should only be cross-examined on what he has testified about, and that, my lord, is on record. He testified that he collected the exhibits, packaged them, and sent them off to ballistic. If there's any other point, my lord, that the court would like to hear me on, I will gladly address the court on such point.
I think I will make comments which will determine whether you want to add to what you have said. We will then determine from your colleagues, Advocate Defo and the attorney with him, whether they want to leave it to the chronology they have outlined, that we then allow time for a response to this. The reason why I wish to make comments is because I foresee that we will, in a sense, still proceed before, or we might still proceed before they respond to what we have presented. And I agree with what has been said, that the manner in which this has come on board sort of takes everyone by surprise, in the sense that if it had been submitted, even if you had woken the secretary at night to say there is this, but I take the point that you are saying it has been recently completed.
Yes, my lord, it's hot from the printing press. It was only finalized just before 9, my lord.
Yeah. So I think the long and the short of it is that we are going to give your colleagues an opportunity to respond. But in seeking to find out whether you have anything to add to what you have said, I just want to make the following comments. The first is that the way this trial has been running up till this far has presented problems. Most of the issues that you are raising, in my understanding, should have been issues, and I'm not saying you should not have raised them. They should have been raised on a point to point, and I'll tell you just shortly why that would have been necessary. That as cross-examination happens on behalf of the state, you are seated there, you are hearing everything. I might as well reveal that it has prompted the bench to tread very, very carefully, avoiding to be seen to be jumping into the arena, because in the way I am used to, when a question is raised and it is objectionable, the other party should rise there and there and object to it. Now, the way this has happened, you have even raised the issue that evidence should be expunged, which should never have come on board. And that could easily have been done on a point-by-point basis, instead of keeping quiet and then raising it as you do now. The other comment I want to make is by way of a reminder to everyone, myself and yourself and your colleagues. I don't know how better to put it. This is not our court. This is the court of the people of South Africa. We happen to be deployed in our various roles in it. And therefore, there should be nothing which goes on the basis of who is who. And fortunately, way back, even before we were born, all of us were born, rules were put in place about how this animal called a trial should be run. Books were written on criminal procedure. Some of you even went to law schools to learn the ethics of running this kind of a process, because the three of us, the four of us, know what should be done, or we are supposed to know what should be done. Some of the people in this courtroom don't know the depth of the rules in operation. And when we run a trial the way we are doing, we are creating an impression that should never be created. It is never about what Judge Maumela prefers. It is always about the facts, the law, and how the law is applied to those facts. But closely to what you are raising now, it is also about, from olden times, in our statute, in our textbooks how it has been depicted, how a trial should be run, how the various roles should be played. And when it happened, you know, I can give you an example. Last week, there was a quip. After there was no objection, and I saw the danger of going where we are, and I needed to stop it. And then the next question was, if I give you an example, the next question, it was directed to the witness. Oh, before I'm accused again of repetition, then the question came. We cannot run a court that way. We cannot. Because then it is us. It is no longer the issues, it is no longer the victims, it is no longer 5 men who are in custody, some of whom may have built homes to sleep in. They are not sleeping there because there is this trial and there is this determination that they will be in custody. So much as I appreciate what you have come up with, I also want to comment that most of the objection should have happened there and there. So that we don't even spend time like we are spending now, revisiting things that have already happened. Having said that, like I said, I'm going to give your colleague an opportunity to give the indication. The earlier indication we got is that they are going to read your submission. The reason why I made the comments I did is because if they choose to read the submission and then respond later, and in the meantime we'll be running the trial, my aspiration is that some of the things that should never happen in a trial should not happen whilst we await this process you started, this issue you raised, to be dealt with adequately.
Indeed, my lord, can I just quickly respond to the first issue that the court raised as to why the objections were not raised at that particular point in time?
Yes.
Yes. My lord, will recall that when we adjourned on Tuesday, the questions regarding ballistics had just been put to the witness, and just before that, the issue of the DNA was put. So the questions were just put before we adjourned. My lord, the cross-examiner is allowed, as we indicated in our submission, some latitude. You don't want to jump up and down like a jack in the box. That will make the flow of the trial, my lord, impractical. The record will be very difficult to read. My lord, will recall that we did raise objections on certain issues which elicited acerbic comments from my friend, my learned friend. Unfortunately, generated a lot of heat, and unfortunately, my lord, with less light thrown on the on the issues that that we've raised. And there's also, as the court has pointed out, there's duty upon counsel to make sure that you fair to the to the witness. You only put questions that are fair, and my lord, as I've just indicated, that the state was on the point, and sometimes you just feel like you think it's an odd question that slipped in by mistake, but there's now this persistence. There's a trend. It's continuing, and this is where, my lord, we felt that this has got to stop. And that is the reason, my lord, why we're holding off a little bit, and I think things have now reached a stage, my lord, that it cannot be allowed to continue.
Advocate Tefo?
My lord, if I may be allowed, since this issue is dealing with regard to the cross-examination by my counsel, the team agreed that may address the court.
Come again?
Our team, we agreed that I must address the court.
Okay, I'm not hearing.
I must address the court,
Yes.
my lord. As I said, this issue came up because of the cross-examination by my counsel.
Yeah.
My lord, if I look at this document, doesn't even have a citation, whether it will be a court document or what, we don't know from the state today. I want to emphasize one point, which is very important. I agree with the court. The quorum of the court must always be maintained and follow the correct procedures and do things the right way. I agree with the court 100%, which I'll also discuss it with my team. This document from the state is even mentioning accused number 5, whose counsel has not even cross-examined. I found it funny. And
Is
the
that,
reason
is,
I'm
that,
raising
is that not the kind of comment you can include in your heads? Because now you are deviating to
yeah,
the
what
issues
I'm
of
trying to
accused
say,
number
my
5.
lord, is
Yes.
we'll request the matter to stand down. We look at this document with the direction of the court in order for us whether we are proceeding today or we are postponing. The state prepared this document, which according to me, according to us as a team, my lord, it is a document that can emanate from a trial within trial.
I don't know
Because
why. I don't know
there are
why.
heads of arguments, my lord. I'll stop here, my lord.
Yeah.
However, I'll request the court to give us time.
Before you sit down, I don't
Yes.
know why you are hammering or hammering on the issue of a postponement. I have said the aspect of ambush that was raised is acknowledged. That is why we are going to give time for you to respond to this document. And that is why, it is exactly why I made the comments I did. We are running a trial. It's a criminal case, state versus Severe and others. Our tools are the Criminal Procedure Act and other writings, including books on criminal procedure. All I'm saying is that let us stick to that. And I have tried, if you were here,
Yes, ma'am.
I have tried to intervene. You know, a witness says, I'm an expert in ballistic. The next sentence comes, you are a mastermind. And I tried, so that we take that out, I tried to intervene. What am I accused of? I'm accused of suppressing. A repetition happens. I intervened. The state didn't raise it. I intervened to avoid repeating, so that we run this trial with reasonable speed without compromising the quality. The comment that comes is that I want it to be recorded that I am being suppressed and the rights of my clients are being undermined. And that comment is coming where we all know, we all have mics before us, we know it's being recorded. So we take precious time, and that's why I started with the comment, it is not our court, it is not about us. We are deployed in this court to play the roles that we are supposed to play, and we are supposed to use the tools at hand and to follow them. And it's natural to, by mistake, deviate from whatever rule. That the other party is there to raise it there and there. And if you are corrected, it is not necessary to quip back. I could have reacted to it, but it would, again, like I'm saying, it would have been much about myself. And I keep on repeating, it is not about me. It is about a father, a son who lost a life, and it is about some other fathers or children who are not sleeping at home. Let us resolve this matter and determine what should be the case. So I want you to look at that document in your own space and time. I want us to continue with this trial, with the observations I have made. I am saying I was not with you at law school, I was not with you at class, but we all know where to get the procedures to be followed. We all know where to get the rules that are applicable, and let us follow them. And if I by mistake, and which will happen even from the bench, if I by mistake and it is pointed out, let us address that and go on without bringing in snide comments that feed the wrong constituency. You know, with things like this and the trial being run like this, there are people who are waiting for just those moments. They don't care what Mrs. Meyiwa thinks. They don't care what the father of Sibia and others think. They don't. They are waiting for this kind of comments, and they make these comments make their day, whilst they destroy everything we are about. And I'm saying, appealing to the good consciences of everyone here, let us get down to business and do it the way we were taught, the way we read, the way we studied. Let the matter start and end there.
I agree with the court, Your Honor. My last submission is that when you do cross-examination, my lord, allow me on this one. I know I don't want to answer here. I just want to raise this point. You put a version to the witness from the statements which are provided by the state. We are allowed to do that.
Yeah.
I stop there.
Yeah.
Thank you. I'll request that we stand down for now. I discuss it with my counsel. Then we'll come back.
For how long? For how long?
It's not long, my lord, maybe 10 minutes, but I will allow our colleague also to address the court. If he so wish, my lord.
Advocate Mchololo.
As the court pleases, my lord. My lord, after hearing the submissions made by the state, we ask, my lord, that we also be given time to prepare also our substantive response before his lordship make a ruling over the objection raised by the state. As the court pleases, my lord.
Advocate Baloyi.
There's no objection to that, my lord.
Sorry, my lord, I just forgot one thing. Before we prepare our response, I just want to get clarity from the state in respect of paragraph 13. If I was included by error or it was intentional.
My lord, there's patently just a typing error. We know that accused number 5 hasn't started cross-examining. It's supposed to read the counsel for accused 1 up to 4.
Are you satisfied?
Thank you, my lord. I'm satisfied, my lord. Thank you.
It is now 10 hours 37. We need 10 minutes. So let us adjourn for 10 minutes as on the clock.
Final court vote.
Thank you, Your Lordship. Mr. Msir, good morning, sir.
Good morning, Advocate.
How did you spend your Freedom Day yesterday?
These are the kind of issues that we've just addressed, my lord. And as I indicated, my lord, if one will have to object every second question, the record will not read properly, and it will take us an awful lot of time, my lord, to get to this point. If we can just confine ourselves to the issues and conduct proper cross-examination. Mr. God bless.
Advocate, therefore, the witness is there to be cross-examined on the evidence he gave. Let's proceed.
Yes, that's what I was about to do. Mr. Msia, yesterday, the day before yesterday, Tuesday, yes. That will be in relation to. Do you have the charges in front of you? Do you have the charge sheet?
No, I don't know.
Can you give him the charges, Mr. Aloy?
Checklist is this, no? Okay, I got it.
Do you have?
I got them, my lord.
It will be count 4 and 5. This is in relation to alleged firearm in possession of my client during the alleged crime committed on the 26th of October 2014 at the said address 13511 Kutano Street, Muzama section, Fort Loras. Up to that point of your last answer, as a forensic expert, in relation to the evidence you've collected at the crime scene,
Yes, my lord.
forensically speaking, and considering count 4 and 5, the charges against my client 1 up to 4, as the person that who has been at the scene of crime, having done your job diligently and having done your forensic investigation, whereby you paid a due diligence, can you say on your own, is there anything forensically link client 1 to 4 to the scene of crime?
As the court pleases. Well, I'll just say if we go on at this trend, we'll never finish this trial. We've just indicated these are ballistic issues. The state will be calling the ballistic expert and these questions can rightly be put to the ballistic expert.
Advocate Tefo, this is exactly what came up last day before yesterday, when you were repeating issues that relate to the analysis of what was collected. And when I indicated that you are repeating and that it is not a question for this witness, you felt suppressed, unfortunately. But again, you are doing the same. He is not testifying about linking anybody. He is saying, I went to where the deceased was shot. It was in a house. I collected 1, 2, 3. After collecting everything, I took it to where it should be taken. And those people must have done tests or whatever with them. They will come up with what relates to what is linked to whom. And when you ask a question to him about linkages of what was found at the scene or who was at the scene because of the ballistic evidence collected, it doesn't become his question.
Your Lordship, with all fairness, I don't see us continuing here, progressing here. Because Mr. Vale will just object to everything. And the court will take that. Even if when I'm a human being, Mr. Musa is a human being. Even if I have to greet the witness, I'm not a cruel person. I'm objected. I mustn't greet this poor guy.
Greetings
No.
are not an issue. You are doing exactly what landed aside. I don't know why you are doing it. I really don't know why you are doing this. All I'm saying to you is that this question you are raising about who is linked doesn't belong to him. There are witnesses that are coming to testify about it. And that is the basis upon which that question has been objected to. And you are accusing me of taking what was stated by the state. And it is not that. I'm looking at your question and the nature of the witness we have. Looking at the nature of the question you are asking, I'm saying it doesn't, he is right, it doesn't belong to him. You will put that question when the right witness comes.
Then, Your Lordship, will it be fair, with all due respect, I ask my learned colleague, maybe we can stand up, write me the relevant question. Because I said relevancy is subjective. So now it means it is clear that I'm just going to be objective in every question that I have to put before this. Even the version, I do have a version.
No.
I'm prepared.
Don't go to other issues. The question you put has been objected to. I've said to you, it doesn't belong to him. Look for another question and ask it. And if this objection was wrongly taken, you are a lawyer. This trial is proceeding. You are going to address, you are going to write heads, even after, depending on the outcome. You have other processes, many other processes that may follow. This question you are putting has been successfully objected to. Let's look for another question and proceed. If it is also objected to, and I'm not saying it will be successfully objected to, the same procedure. We leave that question, and if that will be tantamount to a very unfair trial, you know what we will do. But let's proceed, please, for the sake of time, for the sake of everyone. Please, let's proceed.
That's what I'm pleading for. So the advice to my learned colleague, Advocate Valoi, as a lawyer himself, though he's been employed by the state, I'm a practicing lawyer myself, different to him. So that process is still allowed. If there has been unfairness here, he also knows what to go next time, the next process.
But
there is a process of appeal. If you feel undone, after everything has been concluded. He can do that, unlike hampering the progress here. Is he who's hampering the progress?
He has the right to object to a question. Go to if we were to adjourn here and we send you to the next court, you'll find people objecting to questions. And after the objection, a ruling, and it moves on. That's how trials are conducted.
And I don't see anything wrong, Your Lordship, when I say, because it was Mr. Baloi himself said, this witness is for the forensic. It's a forensic expert, forensic investigator. What I put to him, it was, insofar as where we are coming from, in the cross-examination, since we started yesterday, up to Tuesday, not yesterday. Forensically speaking, as is the forensic expert, is there anything linking my client 1 to 4? What is wrong with that? And he was about to answer here. He didn't say, I cannot answer.
Sergeant Musia, do you have an answer to that question?
Can you repeat your question?
No, he wants to know
Yes.
whether is there any
Let me repeat the
linkage
question, Your Lordship.
to anyone from what you collected, whether it links to anyone. That's the question.
Not anyone. Accused 1 to 4.
Accused number 1 to 4.
Yes. It's different when you say anyone.
Yes.
I think most of those questions, as the court is being trying to solve this, I would like you to direct those questions to the ballistic expert. I'm only a forensic field worker. I've explained my relationship with this matter, my lord.
Uthi nakaphendula ke lo mbuzo lo abuzwayo ukuthi ingabe ke kibo lofakazi ayakwazi ukuthi abuqoqe lapha kwenze khona liqala leli, ingabe bukhona lobu obulinka wena mangala kweqala kufikela kwesine. Uthi cha yena ke njengoba inkosi yenkantolo beselinga ukuthi ke izame icazule lenkinga, lo mbuzo loyo ke umuntu ongakwazi ukuthi awuphendule kahle ngulo okuthiwa i-ballistic expert noma owazi kakhulu ngokuhlola kwezibhamu, ngokuba yena sekaqhazile ukuthi yena ke ubandakanyeka kanjani kuleli qala, nokuthi futhi yena ke umsebenzi wakhe nje ungwesiforensic, ungumphenyi kulokho ngesiforensic.
Mr. Musia, you are, by your own admission, you are a forensic expert. Am I correct?
As I explained to this court, my lord.
Yes.
Uthi
What I-
uyiqinisile ukuthi uyi-forensic expert?
So you are here to assist this court. Am I correct?
That's correct, my lord.
Yebo kuyiqiniso ukuthi ngikhona futhi la kuzoncedisa inkantolo.
And myself, as I'm standing where I'm standing now, I'm here to defend accused number 1 to 4 against the serious allegations against them. Are you aware of that?
I'm very much aware of that, Mr.
Futhi nalo lwazi lelo nginalo ukuthi umela ukuzovikela noma ngaloqala phela kwesine.
And I'm going to ask you the questions in relation to your job as pertaining to the allegations against my client. Will I be wrong if I ask any question pertaining to that?
Only if questions are based on the crime scene itself and the movement of this exhibit from me to their destination, then I can be able to answer, my lord.
Ngiyakwazi ukuthi ngikwenze lokho ukuphendula ke uma ke lemibuzo izobe iqondene nayo i-crime scene futhi iqondene nabo ke lo fakazi engabucoca i-movement yayo ke ngiyahambisa kanjalo ayala yakhona, ngokunjalo ke ngizokwazi ukuthi lo mbuzo njalo ngiyaphendula.
And remember, the reason we are here as different stakeholders, we are brought here by one thing. First Flores case 636-10-2014. Are you aware?
I think on my side, I only came here for the forensic side, my lord.
Ngicabanga ukuthi ke mina kwelami ihlangothi ngizele kuphela lokwe forensic.
I don't think you did understand me. I'm saying, as the different stakeholders, you are from forensic. I'm the lawyer, representing case number 1 and 4, being alleged of a serious crime at the address where you visited and where you did retrieve some of the evidence as a forensic investigator under case number Phosphorus CAS 636-10-2014. Am I correct? That we are here because of Phosphorus CAS 636.
That's
of
correct, my
10-24.
lord. That's correct, my lord.
Kuyiqiniso ke lokuthi sonke sila ngenxa lecala leli lase Phosphorus iCAS number yakhona ethi 636 of 10-2014.
And you are witness state witness to assist this court.
That's correct, my lord.
Ngiyavuma futhi ke ukuthi nguye ufakazi wombuso futhi ozoncedisa lenkantolo.
So is it within you to confine me which question I must ask and which I mustn't ask you?
As the court pleases, I don't think it's fair to ask that question. The witness is here to give evidence. The court personnel is here to decide what is relevant and what is not relevant.
Question overruled. Let's get another question.
So on the 26th of October 2014, when you arrive at the scene at 12:20, is still your testimony that you found Brigadier Ndlovu there?
That's correct, my lord.
Kuyiqiniso ukuthi ngisemile emazweni ami engiwakhulume phambili ukuthi ke nge-26 zika-October enyakeni ka-2014 ngo-12:20 intathakusa ngiye ngathola noBrigadier Ndlovu la kwenzeke khona liqala.
And it's still your testimony that everything that was explained to you, it was explained by Brigadier Ndlovu as a second person. You didn't speak to the eyewitness at that scene. Am I correct?
I think witnesses, a person who's responsible for taking down statements is the investigating officer. At a crime scene when I arrived, I explained to this court that we usually, it's obvious you have to find the person who called you to attend to the crime scene. It's obvious. I have to go straight to that particular person if he or she is there at the crime scene, especially a police officer. Nobody else, my lord.
Ngifuna ukuchaza ngalendlela ke ukuthi mangiphendula umbuzo wakho ukuthi ke ingabe kuyiqiniso ukuthi ngikhulume naye uBrigadier Ndlovu lo ongasiyo ufakazi ozibonile ngamehlo kodwa kungumuntu wesibili othe wayefika lapho ke ngifuna ukuchaza lokho ukuthi ke kusebenza ngalendlela le ku crime scene. Umphenyi weqala nguyena othatha i-statement kubufakazi. So masifika esigamekweni la kwenzeke khona iqala noma ku crime scene kakhulukazi ke imvamisa ukuthi ngiya kulomuntu ongibizile ukuthi ngize lapho kule crime scene noma umuntu wesifazane noma umuntu wesilisa kakhulukazi ke ngiya emuntwini osembuthweni wamaphoyisa ngisho iphoyisa phela.
Mr. Msia, to that language of yours, of obvious, to my client and myself, we don't accept that language to say it's obvious. Consider the fact that my client have been charged with a serious allegation. Count number 1 says they've killed. Count number 2, they attempted to kill. Count number 3, they assaulted and stole the phone. Count number 4, they had 9mm parabellum, C7. And count number 5, with ammunition. Count number 5, they had live ammunition of 9mm. And they deny each and every charge here. So how on earth you can say obvious? Should now you come to the extent that you say no, it's obvious they've done that.
Maybe I need to repeat myself, my lord. What I was trying to emphasize here, I mean, when I get to the scene, there are obvious situations that I'm used to. That is what I was trying to mean, my lord.
Mhlambe kufuna ukuthi ke ngiziphinde ngichaze kangcono kuleli phuzu leli. Ngisho ukuthi ke ngenjwayelo ke mangifike ku crime scene noma la kwenzeke khona icala ke ngilokho engijwayele ukuthi ngikwenze lo uma ngichaza kahle lenkulumo.
Hence I'm saying that when I say in our situation, SIQs number 1 to 5, don't use obvious to us. It cannot be obvious. That's why I'm asking the question, for you to confirm what you did. So when I ask the question, I'm asking the question out of a lay person from your job. Don't say it's obvious. To us, what you are doing is not obvious. So can you please, when the question comes to you, help this court to answer the question so that the relevant or well-informed decision can be later be taken.
Can I make myself clear in this court, my lord? I'm very confused now. I'm getting confused myself. I tried to give advocate T4 some guideline, not to saying that I'm underrating advocate T4. Now I'm not sure how to say this, but I will try to express myself, my lord. I mean, I'm
Sergeant
someone.
Musia, Sergeant Musia, you should not. The last thing that should happen is for you to be confused. Answer every question as you feel you must answer it.
Oh, thank you, my lord.
If you go out of line, there will be objections. The state might also raise it. Advocate Nchololo might also raise it. I will also indicate if you go offline. Answer the questions. Don't get confused.
My lord, it's like now I'm restricted in this court. How must I express
You are
or
not.
answer?
You are not restricted. That's why I'm saying answer every question in the way you feel you must answer it. As to the effect of your answer, we are here to deal with it. Don't get confused. Don't feel restricted. Give the answer you would give if anybody had asked you the same question.
I'll do so, my lord.
Thank you, Your Lordship. Yesterday, Mr. Musia, you, in the question of, didn't you, when you arrived at the scene, didn't you suspect if the scene might have been tampered with? You remember that question?
Yes, my lord.
Yebo ngiyakhumbula lo mbuzo ongibuze wona kuthanga ukuthi ngesikhathi ngiphinde ngibuya futhi lebesinini azange ngibe nezinsolo ukuthi ke lesini iye yaqajela noma yatemperishwa.
You remember your answer?
I remember my answer very well, my lord.
Yebo ne answer noma impendulo engiyengayinika kulo mbuzo lo ngikhumbula kahle.
Can you remind me of your answer?
The crime scene was never tempered according to my view when I get to the scene, my lord.
Mina ngokubuka kwami ke I-crime scene bekaqajelwa kuya ngendlela engibuke ngakhona.
I remember that answer. You're right, sir. You still remember that we even talk about the time interval as to when you received the call and when you arrived at the scene. We talk about 4 hours. Remember that?
I remember that, my lord.
Yebo ngiyakhumbula nokuthi siye sakhuluma ngendaba yesikhathi ukuhluka kwenkathi ukuthi ke kusuka lekimi ngize ngifike khona lapho kule crime scene ukuthi kuthetha ama-hours le 4 hours.
And you further remember that I did ask the question and you answered that you were the first person, insofar as the forensic investigation is concerned, to arrive at the scene. You remember that?
That's correct, my lord.
Yebo nalombuzo ngiyakhumbula ngesikhathi ungibuza ukuthi kulawe forensic ngabe yimi uqala ufikile ngithe yebo yimi.
I put it to you that, Mr. Msia, that for the first person to arrive at the scene of crime, in your person as a forensic investigator, after 4 hours, is not the right time to act to the scene of crime. It's way too much. Anything can happen there before you arrive. What is your take?
Well, my lord, I think that's a matter for argument. You know, it's not really for the witness to speculate. I think my learned friend can leave that for argument.
I think the witness also said that the timing of his arrival had to do with when he was called, and he speculated that when he was called was determined by what the people at the scene prioritized.
Yes.
I think that is what there is an objection, Advocate Tef.
Okay, Lordship. This is a preliminary question, Your Lordship. I want to put to you, Mr. Msia, I want to put to you that the scene, when you arrive there, it has been tampered with already. I put it to you, the scene, it has been tampered. When you arrive there, things had already happened. What is your response?
I disagree with you, my lord.
Ngiyaphikisana lenkulumo yakho ukuthi ngesikhathi mina ngifika ke lapho ku crime scene le crime scene bese iqajele noma itemperatures.
Yesterday, if I remember, you said actually you didn't ask Brigadier Ndlovu what time he arrived at the scene. Am I correct?
You correct, my lord.
Uqinisile ukuthi ngesikhathi ngifike ufakazi kuthani ngishilo vele ukuthi azange ngibuze yena uBrigadier Ndlovu ukuthi ufike esikhatsini lapho ku crime scene.
Until today, sitting where you are sitting as a witness testifying, you never knew the answer as to what time did Brigadier Ndlovu arrive there, back more than 7 years ago. Am I correct?
You correct, my lord.
Futhi ke uqinisile nakulolu phuzu lelo ukuthi kuze kufike lapho namuhla ngemva kweminyaka esikhombisa angisazi isikhathi lesi uBrigadier Ndlovu ayafika ngaso lapha ku crime scene.
And you said that you found Brigadier Ndlovu with the other police officers. Is that correct?
That's correct, my lord.
Kuyiqiniso ukuthi ngikhulume kanjalo ukuthi ke ngithole na uBrigadier Ndlovu anamanye amaphoyisa khona lapho ku crime scene.
Were you introduced to those police officers by Brigadier Ndlovu?
I see there was no need for me to be introduced to those police, my lord.
Ngithe mina ngibona kunganasidingo sokuthi ngingaziswa kulamaphoyisa lawo.
You see now, you become sarcastic when I ask the question. When I ask the question, I'll now be objected. I'm saying, did Brigadier Ndlovu introduce you to those police officers you found with him there? Yes or no? Why do you become sarcastic?
Depends on how many police officers are on the scene, and I cannot ask each and every one on the crime scene his or her name, my lord.
Kusiya ngokuthi amaphoyisa mangakhe alapho ku crime scene akukhonakala ukuthi ngihamba ngibuze ngamunye igama lakhe.
Monsieur, did Ndlovu introduce you to the police that you found with him?
He
Yes or
did
no?
not, my lord.
Cha azange angazise kulamaphoyisa ngimthole anawo yena uBrigadier Ndlovu.
We could have been done long time ago. And then, were they wearing uniform or private?
Some were detectives, some were in uniform, my lord.
Abanye babo ke kulombuzo wakho ukuthi ngabe bagqoka uniform noma njani, abanye kathi ngabaphenyi, then abanye bagqoke le uniform yombutho wesiphoyisa.
Was there anyone who was senior to Brigadier Ndlovu himself?
My role, as I'm here in this honorable court, I think it was not to secure the crime scene itself, but when I get to the crime scene, the crime scene was already cordoned off, as you can see on my photo album, my lord.
Mina umsebenzi wami njengoba ngifuna utshela enkantolo ukuthi bengasikho ukuthi ngisecure i-crime scene. Ngesikhathi ngifika ke bese velene icordoniwe ivale ngale table ye-crime scene.
My question is about the status of the police. Was there any officer that was above the rank of Brigadier Ndlovu? Yes or no?
Brigadier Ndlovu was the senior officer whom I met at the crime scene, whom I was introduced to, my lord.
uBrigadier Ndlovu nguye ke iphoyisa beliphezulu ngesikhundla engilithola lapha ku-crime scene lele engifike ngaziswa kilo.
Okay. Were you told by any stage that, never mind about Brigadier Ndlovu, when did he arrive there, but did he inform you that before your arrival, in the earlier hours, between the incident of shooting and when you arrived, Brigadier Ndlovu came with the senior officers in that, I'll name them in their specification. Major General Daiwe of Gauteng Province, Major General Musikili of Gauteng Province, Major General Shadrach Sibia, the provincial head of the Hawks in Gauteng, MEC of Safety and License in Gauteng, Ms. Faith Mazibuko. Did he ever tell you about that? They were there.
My lord, I've explained several times regarding, concerning my duties at the crime scene. When I get to the crime scene, there is information that I always look for, especially time of incident and what happened, the summary of incident. After that, I'm becoming busy writing down what is important on my scene report, and then I would concentrate straight to the crime scene to take care of the crime scene, nothing else, my lord.
Ngisengilingile kaningi ukuthi ngichaze ngomsebenzi wami ukuthi ngiyenza njani ke mangifika lapha ku crime scene. Into engifika ngiyenze kuqala ke ngifika ngibhekana naye information noma ulwazi layo le crime scene le ukuthi ke leli qala lenzeke esikhathi sini, ngibheke yona ukuthi amaphuzu amisana leli qala leli ke athini, then bese mangiqeda ke ngibhala le report yami kanjalo kule ncwadi yami isini ukuthi isimi kanjani bese ngemva kwalokho bese ngibheka nanqo naye isini ukuthi kahle kahle kwenzakalani lapho.
Did Brigadier Ndlovu inform you about the people I specifically mentioned? I was not mentioning them for sweet. For the reason why I mentioned those people by their names. They are senior people. Did he inform you about them or not?
He had no time to inform me, my lord, because as I'm saying, I was already busy with my crime scene, and I had no time to concentrate on other matters such as those.
Cha azange abe nesikhathi ukuthi ngitshela ngalokho ngamagama labantu okhuluma ngawo njoba bese ngichazile ukuthi ke bese ngiqalile ngenze umsebenzi wami so benganaso isikhathi sa into ezinjengalezo.
Mr. Msia, I don't have a luxury. Even this court does not have a luxury of time for when you have to answer yes or no, you make in a paragraph. Did Ndlovu inform you, yes or no?
Yesterday, you were against.
I was not here yesterday.
Before yesterday, you were against of me answering yes or no, and you were very cross to me of that. That's why I'm saying at times I'm not feeling comfortable now lately.
I repeat, don't forsake your zone of comfort. Stay in your zone of comfort as you answer questions. Answer questions as you know you should. And you will ask you any question. There is nothing to do with comfort or discomfort. It seeks an answer. Just give an answer.
What I mean is that, my lord, yesterday, before yesterday, it's like I was not supposed to answer in short, yes or no. But I'm surprised to today. Now I must change answer yes or no. Wherever I'm trying to express federally, then I'm no longer supposed to. Then I'm surprised of that, my lord.
Yeah, please change and answer with more than yes or no.
Okay, I'll do that.
Mr. Msia, be informed. I'm definitely not going to make you comfortable. In the best interest of fighting the constitutional rights of my client. You've been at the scene, and you are the right person. Don't expect comfortability from me. I'm not here to make you happy.
Well, I suppose those comments, the last comments will be struck off the record. Just, yeah.
I don't know where we are
Unnecessary.
going with them. And it has been said day before yesterday, he loves it. He loves announcing that he is not here to make people comfortable. I hope he is comfortable, but he's repeating the same thing.
So the answer is that Ndlovu didn't tell you. As I say, you didn't ask.
That's correct, my lord.
Uyiqiniso ukuthi azange ngibuze lo mbuzo lo Ndlovu.
I put it to you that the people I've mentioned, they came at the same time with Brigadier Ndlovu at the scene. And later on that day, the same day, before Brigadier Ndlovu can call you, those people were already left. But before they left, they had a meeting with the family there. They were in the house. Did you know about their meeting?
No, I do not know about that, man.
Cha nginalo ulwazi lomhlangano oyewabanjwa yibo labo okhuluma ngabo kanye umndeni endlini.
I therefore put it to you, Mr. Msia, that go to page photo is the exhibit A, photo 5 and 6. Are you there?
I'm there, my lord.
Do you still remember what you see here?
I know very well what is depicted here, my
Oh,
lord.
you know.
Ngiyazi kahle
Yes.
kamhlophe lokho kubonakala la eyithombeni.
And then you did collect this, some of them, is it? Except the walking stick.
That's correct, my lord.
Kuyiqiniso ukuthi okunye kwawuke ngaqoqa ngaphandle kwayo le nduku yokuhamba noma esitshengiselo ukuhamba.
And this is what you got between 12 and 2 before you left. Remember, you left at 2 o'clock.
I said round about 2 o'clock, my lord.
Which
Ngisho
time?
kanjalo ukuthi ke ngihambe lapha ngenkathi zabo 2.
In case of being comfortable, which time can you say specifically? Can you say 2 o'clock?
I can say 2 o'clock, my lord.
All right.
Ngasho ngithi ngihambe ngo2.
Then I will come with my mathematics. Say you've been there 1.5 hours. If you came 20 past 12 and you left at 2 o'clock.
That's correct, my lord.
Kuyiqiniso ukuthi ngibe lapho for 1.5 hour. Ngiya ngesikhathi engifike ngaso nalese engihambe ngaso.
Okay. Yeah. So I put it to you that this, all right, before I come there, when I ask you about the crash, by the way, what do you call it? You call it walking stick yourself?
Yes, I said that. It's a
Yeah.
walking stick, I said.
Yeah. This, I call it crash.
Okay, my lord.
Yes. And you remember that I reminded you on Tuesday that who does it belong to? This crash.
Yes,
Tumelo Matala.
oh, now I remember, my lord.
Yebo kwamanje sengiyakhumbula ukuthi uye wangitshela ngolesibili ukuthi le nduku yokuhamba ingiyakhe uTumelo Madlala.
And who told you your answer? I mean, the information that you had, that you were told that it belonged to one of the family. You remember that? Who told you that?
The people who were in the house, my lord, they confirmed that.
Abantu bebaphakathi endlini ngibo bebaqiniseka ukuthi yona le nduku yokuhamba ingeyomunye okhona lapha endlini.
Who? I'm saying, people are people. Did the people, I don't know number, did they come to you?
I do not know them by name, my lord.
Labo bantu angibazi ngamagama.
Actually, before you left there, in your first round of coming there, I told Lord, it sounded to me like you only knew Ndlovu. Did you know any other person by the name at that scene at 2 o'clock when you left?
No, my lord. I only knew Brigadier Ndlovu after I introduced myself to him, my lord.
Cha bekho abanye bebazi amagama wabo ngaphandle kwakhe uBrigadier Ndlovu. Lokho kwenze ukuthi ngizazise kuye ngase ngithola ukwazi igama lakhe.
So you were not interested of any person that you found at the scene anyway, except Ndlovu.
That's correct, my lord.
Kuyiqiniso ukuthi benganandaba nomunye umuntu bengimthole lapha ecrime scene ngaphandle kwakhe uBrigadier Ndlovu.
Your Lordship, I'm reminded of the short break, or may I continue?
It depends on whether anyone needs the break, since we took a break earlier on.
Okay.
But nobody is forced to continue. If you want us to continue to stop for a break, freely indicate.
Me, I'm ready. I'm unable for anything.
African challenge.
My Lord, I think it will be the right time to take a short break. Thank you, my Lord.
I forgot to announce we should be back after 15 minutes.
October 5.
some logistical issues. We've already indicated that we'll not be sitting tomorrow, and I think the next date of postponement will be the 30th of May, if that is still in order with council.
Thank you, Lordship. Insofar as the next date is concerned, this arrangement were done during the time of the judicare, during the time of the legal aid. So from our side, we like to interfere with that previous arrangement because they don't suit us. We suggest that we cannot leave May to be wasted. So the consideration should be from the second week of May, because in the first week, 3 up to 6, I do have some cases. So if we can start in the second week of May. I'm not comfortable with the previous arrangement because I was not part of that.
My Lord, there's an aspect we can sort it out amongst ourselves together with the royal planners at the office.
So what will we do?
I think when we take the long adjournment, we will have a discussion amongst ourselves regarding the next date of postponement.
All right, okay. Sergeant Musia, you still under oath?
That's correct, my lord.
Thank you. So your answer, Mr. Musia, said you only knew Brigadier Dove and it was only the interested party you were in, others you were not. Okay. My follow-up question is that you've never specified in relation to your return. Remember the first time you came between 12 and 2 o'clock a.m. Then when did you come back? What time?
As I explained to this court, my lord, due to my health problems, I didn't find time to be in a position of everything, such as pocket book of that year, in that case, so that I can refer to what I have recorded, my lord.
Uma ke ngiphendula lo mbuzo loyo ukuthi ke uma sengibuya hlandla lesibili ingabe ngibuye esikhatsini ke ngike ngaqhaza kuyo le nkantolo ukuthi kuya ngesimo sami sempilo esintekenteke esingasikahle ngike ngaba nenkinga ukuthi ngingakwazi ukuthola ke ngibheke kuyipocket book yami lokho engikubhalile ukuthi kahle kahle ngike ngabuya isikhathi bani uma sengibuya kwesibili lapho ku crime scene.
Sir, when did you know that you are coming to testify here?
This is the 3rd week, my lord.
Leli seliviki lesithathu ngazi ukuthi kufanele ngize ngizonika ufakazi.
So it was enough time for you to make sure that you get everything that you may need to assist the court here. That cannot be excused.
My excuse, my lord, this court do not know the exact problem that I'm sitting with now. It's my back. I cannot be able to sit for long. I cannot be able to drive. But I made some means when the detective approached me regarding this matter to come forward, though, or despite my situation, man. Then that is why I'm here, my lord.
Inkosi yenkantolo noma le nkantolo ke angiyazi kahle isimo sami lesi nginaso esingikhupha kakhulu ngokuba kukwamanje nginenkinga yangapha emva emgogodleni wami kahle kahle eqinisweni angikwazi ukuhlala kahle angikwazi ngisho nokushayela kodwa ke uthe umphenyi wecala ke makangithinta ukuthi ngize ngizoncedisa ngazama ukuthi ngize ke la ngizoncedisa.
What time did you come back to the scene? Approximate time, not approximate time, but yes, approximate, not exactly. You can say plus minus.
As I can
6
remember,
o'clock, 8 o'clock.
as I can remember, my lord, after that crime scene, I received 2 cases which I was to attend, and I had to approach Brigadier Ndlovu and explain to him about what I have done by organizing the senior office, the provincial task team. By seeing the weight of the case, I had to make some means that they should come and help me on that case. And while I was still waiting, then there were cases that came, which I had to attend. And when I came back, I can estimate after 5, my lord.
Isikhathi engasihlanganisa ngisho ngithi ke mangibuya ke okwesibili ingaba la ku after 5 ngokuba njengoba sengichazile phela ke ukuthi ngemva kwale crime scene le bengibukele nayo yalapha ke eFosloras kuye kwadinga ukuthi ke kube nama case amabili efanele ukuthi nawo futhi ngiwa attend ngokunjalo ke ngiye nga approach noma ngaya kuye uNdlovu ngamazisa ukuthi ngalesi simo lesi engibhekane naso nalokho futhi engikwenzile ukuthi ngiye ngaqela ke manje beprovince iprovincial team ukuthi ize izongincedisa kuleli qala ngani ngibona ukusinda kwalo nangendlela kade lenze ngakhona ngokunjalo ukuthi baphinde futhi baze bangincedise labo beprovince ngokunjalo ngisho ke ngaphandle kokungabase ukuthi ke ngiye ngabuya after 5 uma sengibuya ke lapha.
Is it 5 a.m., 5 p.m.?
It's 5 a.m., my lord.
U5 wasekuseni hayi u5 wantambama.
And then what time did you meet warrant officer, the then warrant officer Motlatlu, at the scene?
I think the task team might have recorded their arrival on them, my lord.
Ngicabanga ukuthi laba be task team basibhala isikhathi lesi abafike ngaso.
I'm talking about warrant officer Motlatlu, your colleague from Johannesburg, LCRC. What time did you meet him? Did you find him there? He found you there?
The task team found me at the crime scene, my lord. And I mean, what I'm trying to say is that they might have that record of their time of arrival with them, my lord.
Laba be task team noma leqembu le task team lithole mina lapha ke khona lapha ku crime scene ongikusho ngilungu ukuqhaza ukuthi ngeze ukuthi bona ke babhale phansi isikhathi lesibona abaye bafika ngaso ku crime scene.
Mr. Muse, I don't know what you call test team. I don't know that whether it's a human being or it's what. I'm talking about warrant officer Motlatlu, who will be the witness after you.
Yeah, the task team I'm speaking about, my lord, is the
Warrant officer Motlatlu. I'm not talking about the task team. Can you hear me?
warrant officer. She's now a colonel. Colonel Motlatlu was together with the task team, my lord.
Lieutenant Colonel Motlatlu bekanayo le task team.
Yeah. Did you find him there? It's a lady.
That's correct, my lord.
Yebo kumuntu wesifazane.
Did you find her there or she found you there?
She found me there, my lord.
Ngisho ukuthi ungithole lapho yena.
Okay. And then even the time of departure at the scene, did you leave the scene at the same time or who left the scene first?
We left after 1 o'clock, as I remember, my lord. All of us took the task team and my senior officers from Springs LCRC, then we left the scene after it was completed for investigation, my lord.
Sisuke lapho ngenkathi zokuhamba sisonke laba bangaphezu kwami ngesikhundla balapha e-LCRC yase-Springs siyesahamba sonke ngesikhathi sinye ngemva kokuthi ke siqeda wonke umsebenzi bosuwenza khona lapha e-crime scene.
Okay, and now got the idea now. So first trip, it was 12 to 2, and then second trip, you came at 5 and you left at 1.
That's correct, my lord.
Kuyiqiniso njengoba uyichaza ukuthi ke ehambeni layo lesibili ngibuye lapho ke ngo5 ekseni nase sihamba ke ngabo 1.
So from 5 then until 1 p.m.
1 p.m., my lord, that's correct.
Kuyiqiniso ukuthi ke ngo1 ngemva ke kwamadina noma 1 p.m.
And you have talked about you having the meeting with the Brigadier Ndlovu task team and Mhlahlo. It was during the second visit of between 5 and 1.
Brigadier Ndlovu was not there during our debriefing, my lord. We were only from forensic side.
uNdlovu ngesikhathi ke sesikhulumisana ke bekangekho bengithi kuphela ke laba bephiko lesiforensic.
Okay. Then there is something that doesn't make sense to me. I don't know if this, you were trying to correct yourself or it was afterthought, trying to, okay, let me put it straight. You said in the first trip, you left with bullet, jacket, and the head. You remember?
That's correct, man.
Kuyiqiniso ukuthi ngisho kanjalo ngathi ehambeni lami lokuqala kuya lapho crime scene ngihambe naye i-bullet jacket naso isigcoko.
And you deliberately left the crutch of Tumelo.
That's correct, my lord.
And kuyiqiniso ukuthi yona le crash noma le nduku yokuhamba kaTumelo ngingayishiya.
What informed you to leave this crutch? Why did you leave the crutch and take these two?
The crash, according to the information I received on the crime scene, belonged to one of the victims who were in the house. I saw no reason for me to for it to be investigated, my lord, because it belonged to a person who was in the house.
Uma ngiphendula lo mbuzo lo ukuthi kungani ke ngishiye le nduku yokuhamba noma le crash le kuya ngolwazi engiyangalithola nganikezolo lapha ukuthi ke yona le nduku yokuhamba ke ingayomunye okhona lapha phakathi kwendlu lesingambiza ukuthi uyi victim phela noma ungazimbi. So ngokunjalo azange ngibone isizathu sokuthi ingathathwa ithathwe iyophenywa.
I put it to you, Mr. Msia, that it's natural. This is a crutch, walking, as you call it, walking stick. It's here with other evidence. Just the intelligence of leaving it, having now having the knowledge that it was used to assault the suspect. Why, in your mind, as a forensic expert, it deserves to be left behind? Not taken for the ballistic, for the forensic.
I saw it at the crusher. Having no evidential value, there was no reason for me to investigate it.
Ngibona ukuthi le crusher noma le nduku yokuhamba ukuthi ke inganaso isisindo sofakazi ngokunjalo ke benganasidingo sokuthi ngingaphenya ngayo.
Okay. So when you take these other two items, was Brigadier Ndlovu there?
He was outside the house, my lord.
Ngesikhathi ngithatha lama exhibit amabili noma lobufakazi lobubili yena uBrigadier Ndlovu bangaphandle bangekho ngaphakathi.
Okay. So when you left, Brigadier didn't see you.
I reported to Brigadier Ndlovu before I left, my lord.
Ngiyeke ngazivika noma ngareporta kuyo Brigadier Ndlovu ngaphambi kokuba ngihambe.
But yes, my question is, did you show him what you are living with as the evidence from the scene of crime?
As I've mentioned, the first information that I received when I get to the scene, my lord, there at the kitchen, there was, as I've explained, there was a scuffling between people. Maybe I'm not sure was the victim and the suspect, but there was a scuffling. Having that in mind, as a forensic expert, I saw no reason for me to investigate the crash up, but there was a reason for me to take a photo of that, showing that there might have been a scuffling in the house as I received the information at the crime scene, my lord.
Kuye ngolwazi engike ngalithola lokuqala ke ukuthi ke khona lapha ekitchen kuye kwaba nakho ukudonsisana noma iscuffling phakathi kwabantu abathile, mhlambe ngiyo ivictim noma kanye nayo umsolwa. Ngokunjalo ke azange ngibone ke isizathu sokuthi ke ngingayithatha yona le crash le ukuthi ngihambe ngiyifenyisisa, kodwa ke ngibone ukuthi ke okukhona kubalekile ukuthi ngiyithathe ngiyithwebele isithombe ukuthi ikwazi ukubonakala.
Dear Lordship, may I make a humble plea to can be maybe assisted? Maybe this witness maybe can be assisted in terms of the interpreter. I really find him that he's having the problem with the language. It's not his language, this one.
Is there a word he said wrongly?
You definitely, I'm going south, he's going east.
No, is there a word he misinterpreted or interpreted wrongly?
He just doesn't understand the context of the questions. That gives me the understanding that, impression that the language is a problem.
To whom?
To the to the witness.
Which language? English or the?
I'm talking English, Your Lordship, so he doesn't understand me by the virtue of the way he's giving the answers. So I just feel for him that if there can be, it can be, my question can be interpreted to him with his language. I don't know which language is he. Soto or Sia. Let the court ask him.
Sergeant Musia, do you have a problem of language?
My lord, I don't think I have a problem with the language. It might happen that maybe I don't match Advocate Defoe's language. But unfortunately, my affidavit, everything that I'm doing, it is written in English. There's no way that I can present my evidence in my language, though I'm not qualified compared to him, my lord.
Yeah.
It's not about me. It's about you understanding the questions. You are not answering the question. That's why at long last, I'll feel like I'm repeating myself because you are not answering what you're supposed to answer in terms of the context of the question. So are you comfortable to continue with the English?
I believe I'm answering most of the questions to my utmost best, my lord. Now I'm not sure, I cannot be able to use my language. As I have explained, my work is being done with English, my lord.
Yes, there you are.
I say I should proceed. You don't need the interpreter.
No, I don't need any interpreter, my lord.
Then I hope you are going to answer my questions.
Can I be clear, my lord, just for a moment? Never knowing how Advocate Defoe is expecting me to answer him. Maybe he can tell me how to answer him, my lord.
Then it won't be your answer.
It won't be my answer, my lord.
I think if
you
there's any problem which anybody thinks has to do with interpretation, be it the state or the defense, then it should be noted down. It will be a subject of address. But from what I understand the witness to be saying is that when he works, he employs English terminology. And I'm trying to imagine if he goes to his vernacular, how he would be able to explain things like shrubs, things like DNA. He would only have a statement in the vernacular, and he doesn't feel comfortable with the request that there be use of vernacular language for what he is testifying about.
As the court please, my lord, I'd like to highlight to this honorable court that it is not the question of the interpretation by the interpreter, but then the nature of understanding by the witness to the questions which are posed by the defense counsel. So it's not the matter of interpretation. It's the matter of understanding between the witness and the defense counsel who's posing the questions.
That's correct.
Is there a question he did not understand?
Well, according to the remarks that I heard, I heard the word interpretation. Then interpretation, it involves myself because I'm an interpreter.
No, look, it's not about you. I think the issue is that the advocate therefore is saying that the witness does not understand what he is asking.
Yes, the court please.
Yeah, and I am asking what is it that he doesn't understand? And the advocate therefore is also saying we should switch on to the vernacular, and I can imagine, even in my language, some of these terms, some of these languages have not developed so extensively that you can, at this stage, supplant English with those. Maybe Afrikaans can try to match English for that purpose, but for the vernacular languages, it will be impossible.
Yes, the court please.
Yes. I will try by all means to be slow, and I will ask this witness if you didn't understand the context of the question. Don't be afraid to say, I should repeat my question. I will do that. Is it fine?
It's fine, my lord.
Thank you. Okay. Simply put, when you, in your first trip, were you aware that the stick was used to assault the suspect?
Not according to the information I received, my lord.
Cha kuya ngolwazi lolo engingalithola azange ngikwazi ukuthola ukuthi yona le nduku esetshenziswa ukuhamba iyasetshenziswa ukuthi ishaye yena umsona.
So is the reason that you left it?
That's right, that's correct, my lord.
Kuyiqiniso ukuthi ngiyiso isizathu esenza ukuthi le nduku yokuhamba ngiyishiye.
Okay. And then for the second trip, when you leave the scene at 1 o'clock, did you leave with any evidential material for the attention of the forensic?
I took everything with me to Springs LCRC, and then I booked everything in the SAP 459, which will be booked out for processing in later stage, my lord.
Ngiye ngathatha konke lokho okungufakazi ngesikhathi sengihamba ngo-1 loyo ke ngakufika ke ngakubhuka noma ngakubhalisa lapha eSprings LCRC ku-SAP 459 ukuthi esikhathini esizako kukwazi ukuthi kukhishwe kutholakale ukuze kukwazi ukuprocesswa noma ukuhlolisiswa.
And as I remember, you said in the second trip you took a projectile and you just said the swabs.
That's correct, my lord.
Kuyiqiniso ukuthi ngisho kanjalo esikhathini ezulu ukuthi ngesikhathi sengihamba ngelihamba lami lesibili ngithethe i-projectile kanye nama-swabs.
And the head, I mean at the cap.
That's correct, my lord.
Kuyiqiniso futhi nako lokuthi ngingathatha nesigqoko.
The head, isn't it?
That's correct, my lord.
Kuyiqiniso ukuthi ngingathatha naso isigqoko.
Second trip.
That was the first trip they had.
Isigqoko ngisithethe ngohambo lokuqala.
Or second trip you took the cap.
I mean,
The cap. Second trip.
I mean,
You took projectile, swabs, and cap.
no, a cap, I collected the cap on my arrival on the scene before the provincial CSI team arrived, my lord.
Ikepisi ngilithethe nengifika kuqala lapha esini ngaphambi kokufike laba ke be-provincial.
Or first time
That's correct, my lord.
in 12 and 2.
That's correct.
Ngithethe nengifika kokuqala lokho ama ngifika ngesikhathi sika-12 lokho ngizoze ngihambe ngo-2.
So it means first trip you took bullet jacket, the head, and the cap.
That's correct, my lord.
Kuyiqiniso ukuthi kulwabo lokuqala ngithethe ne-bullet jacket, isigqoko kanye nalikepisi.
Okay. All right.
I'm sorry, mention has been made of a cap.
A what?
A cap. I don't remember the witness mentioning that, he took a cap with him, just a hat, in case there's a misunderstanding.
Advocate?
There was a mention of the cap, Your Lordship, and then at the same time when he said he made a mistake, then I cancelled the cap. It's on record. So he said no. I took the projectile and the swabs. He cancelled the cap. So now.
But were you not mentioning the cap now? The cancelled cap?
No, in the first trip, you talked about this. The head is this many color. This head with many colors, black, white, scotch, what. This is what he said he took in the first place, the first trip, with the bullet jacket. And then, when asking him about the second trip, that's where he mentioned the cap himself. So that's where I wanted to.
No, Mother, the witness has never mentioned a cap. He has always mentioned a hat.
Sergeant Musia,
Yes, my lord.
was a cap among the people, the things you collected?
No, there was a head, my lord.
Cha ikepisi bengekho kulezinto engizithethe ngokuyisigqoko.
Mr. Mtsia, can you explain this mystery here, insofar as the items you collected? First trip, you collected the bullet jacket, according to you.
That's correct, my lord.
And second trip, you collected the projectile.
That's correct, my lord.
I put it,
Kuyiqiniso ukuthi ehambe lokuqala ngicollecte yona i-bullet jacket, and then ehambeni lwesibili ke kula ngicollecte khona i-projectile.
I put it to you, Mr. Msia, that the evidence you've collected in both occasions, they were all been staged. When you arrive first time, you find what you find there. It was just put together, deliberately, intentionally, for you, and you unwittingly being oblivious of this tampering with the scene. You did your job. I don't blame you. You did your job, but you were oblivious for the fact that these things were planted.
I don't think my decisions when I get to the crime scene as my daily activities, I know what to do when I get to the crime scene. And there are what can I say?
Do you
The
want
way
to,
in which the crime scene.
what language do you speak?
No, I'm trying to I'm speaking Sotho.
Okay. All I want to say is that if you get heavily stuck about terminology, you can even say it in Sotho.
Thank you, my lord. In most cases, the way the crime scene is found, I cannot judge any tampering or whatsoever. The only thing that I must do is to secure whatever that I found at the crime scene and make sure that I do the necessary according to my job description, my lord.
Uma ngiphendula lo mbuzo wakho lo othi wona ke lamahamba wami omabili la ngesikhathi ngiya lapho ku crime scene awungiboni iphutha ke wena kodwa konke lokho obekukhona engifike ngakuthola ngakuthatha izithombe into beyihleliwe izinto beziplantiwe khona lapha ku crime scene kodwa uthi mina awungiboni iphutha ngokuthi bengenza umsebenzi wami. Ngifuna ukuchaza lokho uma ngikuphendulela lo mbuzo wakho ukuthi kaningi mina mangifika ku crime scene njengoba kuwumsebenzi wami wangemihla ongiwenzayo ngiyazi ukuthi yini ekufanele ukuthi ngifike ngiyenze mangifika lapha ku crime scene. Ngokunjalo angijaji mina izinto ngendlela ezingakhona kodwa into ekhona ke ukuthi bonke lobufakazi obukhona kule ndawo lobo noma ama exhibit ke ungathwebule kahle izithombe bese ke ngisekira naye isini ngenze umsebenzi wami ngendlela enjengaleyo angibheki into zokuthemparisha.
You remember, Mr. Msia, I said to you that, as you said yourself, you found Brigadier Ndlovu there, and it was Brigadier Ndlovu who was pointing to you what to take, what to photograph, and what not to take. You remember you are saying in your affidavit that you were pointed by Brigadier Ndlovu at the scene.
That's correct, my lord. To add on that,
Don't add, just that.
Kuyiqiniso ukuthi yebo nguye ke uBrigadier Ndlovu bekangibonisa izindawo noma ngithatha izithombe.
The action of Brigadier Ndlovu at that scene was to make sure that he's managing you and intimidating you as the senior. That is resulting from that meeting in that house before you arrived.
that one, I cannot comment on that one, my lord.
Ngale nkulumo yakho qedwe kuyisonto zamanje ukuthi lo Brigadier Ndlovu ke bekazama ukuthi angelawule futhi angisabise ngenxa yomhlangano bebawuphethe endlini qha lapha angeke ngikwazi ukuthi ngingaphawula ngale nkulumo leyo.
Yes, you don't know that. I put it to you because you were oblivious of that fact, that the scene was staged. If yourself, Sergeant Msia, and I forgot to congratulate you because you were constable by there. Congratulations, Sergeant. How on earth, forensic expert, you can be guided and directed by Ndlovu, who never attended a forensic course for 1 day. How could that happen? Is that no stretch?
What I can say, my lord, our departments are different. Our activities are very different. Brigadier Ndlovu has got nothing to do with forensic. He knows nothing, I guess.
I agree.
And every information that I receive, I dwell on that first information that I received. It is the information that will guide me what to do on a crime scene. I don't think Brigadier Ndlovu, as my senior in my field of forensic, can tell me what to do, my lord, because he handed the crime scene to me, and I handed the crime scene back to him when I was done during my first visit, my lord.
Uma ngiphendula lo mbuzo loyo ngile ngokuchaza la ukuthi ke imisebenzi yethu esiyenza kumina no Brigadier Ndlovu ihluke kakhulu, akazilutho yena ngophiko lolu emsebenza kulo lwese forensic. Ngokunjalo angeke akwazi ukuthi yena angangigayida noma ngidonse phambili ukuthi ngenze njani umsebenzi wami. Okukhona nje kubalekile ukuthi mina ke ngibheka lo lwazi engilitholako noma le information abanginikeza yona, bese ngiyo le information engiyilandelelako ukuze ngikwazi ukwenza ke umsebenzi wami ngendlela engiyo. Okukhona ke ukuthi yena uBrigadier Ndlovu uye wathatha i-crime scene wayehanda off kimi ukuthi mina ngiyenze umsebenzi wami. Ngathi nami masengiqedile ukwenza wami umsebenzi ngase ke nginikeze i-crime scene futhi ezandleni zakhe. Ngiyabisela.
Exhibit A, Mr. Msia, page 3. That is your affidavit. I'll read paragraph 3 from your name for the record. Are you there?
Yes, I'm there, my lord.
On 2014-10-27 at 12:20 a.m., I attended a scene at 13511 Kutwano Street, Muzama section, extension 11, Phosphorus, where I met Brigadier Ndlovu, who pointed out certain points to me, of which I took photographs. Close quote. It was you.
It was me, my lord.
Yebo uyiqinisa ukuthi njengoba uqeda ukufunda kuncwadi efungule yami yimi engibhalise lokho.
Didn't Brigadier Ndlovu tell you what to do? When he was pointing?
He only related the crime scene to me, my lord.
Uye wamtshela nje kuphela ngayo i-crime scene.
Mr. Msia, you do everything in English in your work. When I say Brigadier Ndlovu, who pointed out certain points to me, of which I took photographs, close quote. What is that you meant?
Is the information I received from him, and he pointed the crime scene and left me so that I can take over with my crime scene, my lord.
Ulwazi engilithole kuye wasangikhomba ke ne-crime scene ke wayeka konke ukuthi ngiqhubeke ngalokho ifanele ngokwenza inkosi enkantolo.
I put it to you, and this is the last time, that the crime scene was stage managed as a result of the meeting which was held by the senior officers of Gauteng in that house with the owner of that house. And Ndlovu was left there to call you, and when you arrive, he can manage you. You were managed. And then this means the crime scene was tampered with. Do you have anything to say?
No, I got nothing to say, my lord.
Akukho engingakusho manje lo daba lokuthi ke uNdlovu bekangimaneja naye i-crime scene le iyaqatshelwa.
Yes. If you are still of no affirmative with what I put it to you, I should go further to say, as an expert yourself, Mr. Msia, you can be told I don't think you cannot be told by someone who doesn't know your job, yourself being expert, and you confirmed to me that President Love knows nothing about your job. Then how on earth you deny that you were indeed managed obliviously?
What I have just explained to this court, my lord, after approaching the first member I found on the crime scene, he would give me the information I require from him or her. By so giving the information to me regarding the crime scene, automatically, as it is my duty attending to crime scenes, I know what to do, my lord. I don't think someone can come and tell me unless my senior officers at my office or under crime scene investigations, my lord.
Njengoba sengikhazile ngaphambili ngifuna ukuyichaza futhi ukuthi ke mangifika lapha ku crime scene ngiya kuyimember ke eyoqala eyafika lapha ku crime scene, noma ingaba ngowesilisa noma ingaba ongowesifazane, bese ke yena nguye onginikeza ingxokakha noma information mayelana nayo crime scene leyo. Ngokunjalo ke mina ke sengiyazi ukuthi ke yini into ekulindeleke ukuthi mina ngiyenze mayelana nayo le information anginike yona. Akekho omunye umuntu ongakwazi ukuthi ke angangilawula mhlambe or angimanage noma ingaba ngumkhulu ongiphethe e-ofisini lethu noma ke iphoyisa elikhulu.
I'm talking about Brigadier Ndlovu, not a member of the family, whom you never spoke to, because your testimony is that you were only interested in Ndlovu, and the only information that you had when you left the place there, in between 12 and 2, it was all that you were fed by Ndlovu. Was that not your testimony?
I've made myself clear to this honorable court. When I get to the crime scene, as a member who is on the scene, irrespective of his or her rank, I rely in approaching the member of the police who can relate the crime scene to me, my lord.
Sengikushude ngaqaqa lokho ukuthi ke mangifika lapha ku crime scene ke ngiya kuyo lelunga lombutho noma imember yesiphoyisa ekhona lapha ku crime scene ukuthi enginikeze ulwazi noma information mayelana naso i-crime scene leyo.
And I put it further to you, Mr. Msia, that resulting from that meeting of the seniors of Gauteng and the family, the owner of the members of the family in there, before your arrival, Ndlovu was then given the freedom of that house and the license to call a member of the forensic to come at the scene for procedure purpose. Hence, when you arrived there, it was him, not the family member. And further to that, you did not even find the family member there. What do you say?
And further, can you repeat that, my lord?
You did not find the member of that family there. They were not there. It wasn't Ndlovu given the right, the freedom of the house.
I've explained to this court, after I've just arrived on the scene, they arrived from hospital. I was not even ready to begin with my duties, my lord.
Sengichazele enkantolo ukuthi ke ngesikhathi ngifika lapha kwenzeke khona iqala laba bomndeni bebaqeda ukuya babuya esibhedlela.
Who are those people you are talking about who came from hospital? Can you specify?
I cannot be able to specify, my lord.
All right.
There were 5 people on the crime scene. I'm not sure who are those people.
You cannot
Angeke
specify.
ngikwazi ukusho ukuthi bobani kodwa beyibantu abayisihlanu khona lapha ku crime scene.
You cannot because it's not true what you are saying. Let's go to, just to prove that point that the incident, yes, actually it happened at +7, not at +8. The shooting of the deceased, it happened at +7 on the 26th. So, in actual fact, I'm not inviting, actually I put to you what is the correct information. So if I was to be hard to you, I say, actually you took 5 hours to be at the scene, counting from 7. So, or do you want to say anything before I proceed on that? That the actual incident of shooting happened at +7, not after 8, as per Ndlovu's information. Ndlovu was not there. He was just feeding you with the wrong information, as I said. Deliberately so.
Once again, there's no basis laid for why the question is being put that the incident was after 7. We submitted that question should not be allowed unless if my learned friend was to explain to the court as to why or what his source of information is.
Advocate, therefore.
Thank you, Lordship. When I took the instructions, immediately, we have made our own research or investigation about the whole situation for the benefit of our client. Hence, I put to him as part of our own investigation or research. Thank you.
Advocate Balui.
Well, once again, it doesn't really take the matter any further. If they were to say this is the information that that we have, and according to this information, the incident happened at this particular time. I think, unless and until that happens, my lord, it would be misleading to put such a question to the witness.
You say you conducted your own investigation.
Conducting my own investigation or research, I'm referring to the disclosure. I got the disclosure in relation to this matter on the 10th of February this year. So we went through each and every document. So there is a witness who happened to be the neighbor who had the gunshot at +7.
Advocate Balui.
My lord, we don't want to belabor this point. We've put on record what our view is. If my learned friend still wants to continue, we're not going to.
I can't hear you.
If my learned friend is going to continue with that question, we are not going to raise any further points except what we've already put in on record.
Yeah. Do you have a response to that?
No, my lord.
Thank you.
Yes.
Yes. You were the one who was taking the photograph, isn't it? In 12 and 2.
That's correct, my lord.
Did you
Uyinkosi ukuthi yimbe ngithathe ithombe phakathi kwesikhathi lesika 12 no 2.
Did you continue doing that even in the second visit?
No, during the second visit, Colonel Mhlahlo was responsible for taking photos. I was responsible for collecting and packaging exhibits, my lord.
Okay.
Ehambeni lesibili ke uKolonel Mhlahlo nguye ke bebenza lo msebenzi wokuthatha izithombe. Mina owamsebenzi bekucollecta nokupackage wona exhibits.
Let's go to page 10 of Exhibit A, Mr. Msia. Is the sketch there? You see the sketch there by A1.
Yes, my lord.
Are you the one who took a photo of that room from outside?
From which photo, my lord?
No, well, page 10 is a sketch.
It's a sketch, my lord.
Yes. Can you see that we have written? You were showing us about bedroom 2.
That's correct, my lord.
Yes. And you say in this bedroom 2, there were 5 adults and 2 kids. 2 children.
I'm not sure how many there were, but we managed.
No, there were 7, including the 2 kids.
Yes,
I'll
but
just remind you of that.
my intention of deciding to take those people inside the house.
I'm not there yet. I just want you to confirm that.
That's correct, my
Is
lord.
this bedroom 2 where 5 adults and 2 kids were
That's correct, my lord.
confined?
Yebo kunjalo ukuthi kuyele bedroom number 2 lapha abantu abadala besihlanu ingane ezimbili bezingakhona.
What was the time when you were confining these people in this room?
I never put that on record, my lord.
But
Isikhathi sokuthi ngibafake nini lapha ke ngaphakathi kwale room yazange ngibhalisele ekhothini.
But it was between 12 and 2,
That's correct, my lord.
Kodwa ke beku between 12 and 2.
early hours.
That's correct, my lord.
Do you remember the ages of the kids?
No, I cannot remember the ages, my lord.
Iminyaka labantwana ngeke ngikwazi ukuyikhumbula ukuthi bebadala kangakanani.
But they were very young for them to still be alive between 12 and 2 a.m. Can we agree on that?
I do
Like
agree, my
awake.
lord.
Awake.
I do agree, my lord.
Ngiyavuma ukuthi ke bese sebancane kakhulu ukuthi ngalesikhathi leso kuba abakalali basavukile.
On just personal level, without undermining you or disrespecting you, Mr. Msia, I don't think you can allow your child to sleep after 12. Can you?
As the situation was at the house,
Just on personal level, on
yes,
us.
as the situation was in the house, I think those children were not gonna sleep as normal as every day.
Yeah.
Because of the situation, the incident occurred on that house.
Yeah, what happened before you arrived?
Ngenxa yesimo besikhona lapha kulendlu abantwana bekade ngeke baze bakwazi ukuthi bangalala njengenjwayelo njengoba la ngemihla ngenxa yesimo besikhona kulendlu le.
I think it's not only the child, even the adult people, for what happened in that house. Can you agree on that? It will be difficult even for the adult. Isn't it?
Can you repeat the question, my lord?
I say the situation, the way, the incident, the way it happened on the 26th of October 2014 in the sitting room. Whoever witnessed that will definitely, naturally have a shock. That person, if he's got a conscience, won't sleep well in that house. Am I correct?
You're correct, my lord.
Yebo qinisile ukuthi ngenxa yesimo lesesenzeke lapha endlini vele umuntu okahle nje bengeke akwazi ukuthi angalala kamnandi.
So now, this sketch, as it is on page 10, you told us on Tuesday that you were doing your job here and you confined these people in this room, bedroom 2, 5 adults and 2 children, and who, I believe that you believe they saw the incident, they were eyewitnesses. Isn't it? They were eyewitnesses to the incident?
What I was trying to do at the crime scene is to control the movement of anyone who is in the house, so that they cannot tamper with evidence. That's why I was taking those people in one bedroom.
Yeah.
Yes, my lord.
lokhu bengikwenza ke lapha kule ndlu leya ukulinga kulalo imihambo yabantu ukuthi bangakwazi ukuqaphela ke lesimo sofakazi silapha kungakho bengibathatha ngibafaka ekamereni endlini.
I agree with you there. You were doing your job, you were taking the control because you are the owner of the scene now as a forensic expert. You don't need to be disturbed. Yeah. But now, at that time, did you really find the people to confine in bedroom 2? Were the people there? 5 adults, 2 kids.
I never said all of them because the other 2 were men. I think
Correct.
what we were doing is try to accommodate these minor children with these 2 victims, with these other female victims in the house. I'm not sure whether both the other 2 of which are men, they went into that bedroom because I was then busy with my crime scene, and they they remained in that bedroom until I was done, and I asked my senior whom I handed back the crime scene to, of which is Brigadier Ndlovu, about my leaving.
2 o'clock.
About me leaving the crime scene because of the reason that I received other cases. And I know whenever I hand back the crime scene to a senior person as Brigadier Ndlovu, I think he knows much better than me concerning the securing of the crime scene, my lord.
Uma ke ngiphendula lo mbuzo lo ngifuna ukusho ukuthi ke nebesilisa phela bebakhona ababili ke kodwa ke ngifuna ukusho ukuthi ke kule kamera lelo ne bedroom number 2 ke angeke ngiqinisekise ukuthi ke bayangena lapho ngaphakathi okukhona besizama ukuthatha labo besifazane enkhulume ngabo nezingane ukuthi zibe lapho ke bese ngikwazi ukuthi ngiqhubeke mina ngiyenze lo msebenzi wami ebengizowenza kule ndawo leyo ke mase ngicela ke ngomsebenzi wami obungiwenza lo ngase ngithatha ke le crime scene nginikeza kulo omkhulu kunami ngokwerank ukunguye uBrigadier Ndlovu. Ngithemba ukuthi yena uBrigadier Ndlovu wazi kakhulukazi ukuthi yona ke i-security noma i-crime scene angayisekhwela kanjani njengoba senibuyisile ngabo.
Just a word of advice, my dear brother Msia. When I ask the question that need yes or no, or just a one line in you to respond, and then you respond in assignment, you invite more questions that you're not going to answer. Just confine yourself to my question. We will have the progress.
I'll try to do so, my lord.
All right. Where is this photo of bedroom 2 in the reality? Do we have it?
Bedroom 2 was no longer a crime scene, my lord.
I-bedroom number 2 bayengasayi yona i-crime scene.
No, I never talk about crime scene. Crime scene is the whole house, isn't it?
That's correct.
The whole
but
yard, the whole yard.
Yes,
From
but-
the lawn there, next to the edge
Yes,
of
but
the road.
we decided even to swap bedroom 2 because of that reason. Then we had to use that bedroom to secure these victims because it was during the night. Then there was no need for us to investigate that bedroom, my lord.
Bengasizathu sikithi ukuthi ke siphenye yona le bedroom number 2 mara kukhona siye sawenza amaswaphu kanjalo kule bedroom number 2 mara sayisebenzisa futhi ukuthi ke sithathe labantu laba engikhulume ngabo ukuthi sibafake ngakiyo ngaphakathi.
Yeah, you didn't understand myself. Let me repeat myself without you asking me. I say, this is a sketch. Page 10 is a sketch. But there is a photo of this where you can show or you can refer. So no, bedroom 2 is on this photo. For example, 3 and 4. I see the outside of the house. Can we see bedroom 2 from the outside?
From the outside.
Yeah. Where you took the photo.
Yes,
Isn't it that you took this bedroom to a photo, but you took it from outside? You didn't take the photo inside with the people?
yes, that's correct, my lord.
Yeah. Can you take us elsewhere where we can see this bedroom?
This bedroom.
Yeah,
I
the
think
outside.
I even marked it yesterday.
Sure.
Then otherwise, I must go around the page. The photo, there's no photo. Then must I take this around?
But no. I'm just say which page?
It's the sketch, page 10. Page 10.
No.
We
Okay,
sketch
let-
lapho
let me-
ku page number 10
let-
exhibit number A.
Let me be slow. I'm at the sketch. It's me who took you to the sketch. And then here at the sketch you say, this corner room is a bedroom. Is a bedroom 2. But we see on the sketch. So I believe that you said, like you say, you did take a photo of this house. And the way there is bedroom 2 that we can see on the photo.
If I can be maybe of assistance to my colleague, if you look at Exhibit B2 on page 16, there is a key to the photos and sketch plan. And photo 40 to 47, this is now the photo album of Lieutenant Colonel Mhlahlo. It says indicates the bedroom is found, second bedroom from the toilet and second bedroom from the sitting room. Perhaps that might be of assistance.
Mr. Msia, I hear what Mr. Valo is saying, but I'm not listening to him because I'm talking to you as a witness there. You are the one who were there. Okay. Did you take the photo of this bedroom 2?
From the outside.
Yes.
I think it appears clearly on my establishing shots and again on Lieutenant Colonel Mhlahlo's photo album. It can appear, my lord.
No,
Yebo le ndlu ngeke ngayithebula ngaphandle ithembe iyaqaqa kahle. Iyabonakala lapho futhi izobonakala la kuyithombe ezizathwetshulwa ngu Lieutenant Colonel Mhlahlo.
Okay, let me ask you differently. You agree the whole house is a crime scene,
I agree, my lord.
Yebo ngiyavuma ukuthi yonke indlu kuyi-crime scene.
and everything within this house as a scene of crime must be exposed, must be visible to the next person who cares to know what happened, isn't it?
That's correct, my lord.
Yebo ngiyavuma ukuthi yonke into kumele ithathwe ke iboniswe komunye umuntu ozobuka ukuthi akwazi ukuzisa ukuthi ukwenzakaleni.
Why didn't you take the pictures of this bedroom 2 inside, where we can see, no, these are 3 women, these are 2 men, these are kids. Why didn't you take it from inside?
Was I supposed to take pictures of people at a crime scene?
Bengifanele ukuthi ngithathe iy'thombe zabantu lapho ku-crime scene.
You are here to answer my question. I'm not going to answer your question.
I don't think that was necessary, my lord.
Angiqabanga ukuthi lokho bekubalulekile.
I therefore put it to you, Mr. Msia, that what is the relevant words? It's true. There were never people here. You're just blinding us. There was nobody here. There was no that 5 adults, 2 men, 3 women, and the kid at that time of the night or early morning. You are not talking the truth.
I think I was there, my lord.
Ngicabanga ukuthi bengikhona lapho ke mina.
You could have been showing us the picture. You say photo number so and so. You can see those people. They were in bedroom number 2. But now you are showing us the sketch here. You even want us to write bedroom 2. This is not bedroom 2. It's just a drawing. Why didn't you want to make us to believe? Because here we are in court. We work with the evidence. Seeing is believing.
I think, my lord, regarding crime scene, I've been taught regarding crime scene, even though Advocate Tifo cannot regard me as qualified for this job. I'm listening to him every
I
time.
never said you are not qualified. Sir.
I think I know the crime scene. I was taught about the crime scene. And that particular bedroom has nothing to do with the actual crime scene according to the first information of crime. That's why we decided to place those people inside that particular bedroom for them to be safe during that time of the night.
Ngifuna ukusho ngiphendule ukuthi ke ngiye ngafundiswa mina ngayo crime scene futhi ngiyayazi ukuthi i-crime scene yize ku-advocate ke angithathela ukuthi umuntu ophansi ongakwazi kahle umsebenzi wami kodwa okukhona ngifuna ukuqaqisa njengoba ngifundisiwe ngiyazi ukuthi ke leya bedroom number 2 bengabanekanye indawo ngayo i-crime scene le kungakho ke sesathatha labantu engikhulume ngabo sabafaka ngaphakathi kwalelo gumbi leli bedroom number 2.
The people in this house, the people in this house, the people in this house who were there when the incident happened, that past 7, 8, they didn't sleep in this house. They left before you arrived. They went to sleep at Mr. Chikotola's house that night. They were not here. What do you say?
Maybe that was after I was done with my crime scene until the morning when the CSI team arrived at the crime scene, my lord.
Mhlambe lokho okhuluma ngakwenze ngemva ukuthi ngiqeda ukwenza umsebenzi wami ngihambe sekufika la be-CSI ekseni.
Your Lordship, reminded of the lunch.
May we be promptly back here at 2. We are tending to wait for one another after the agreed time. Sergeant Musia, you still under oath?
That's correct, my lord.
Mr. MC, in relation with the alleged tampering. Okay, firstly, I just want to correct something, Your Lordship. In relation to the people who went to the scene, I mentioned their name, the senior officers of Johannesburg. Instead of MAC Faith Maziboko, it will be Nkosi Malubane in 2014. Not Maziboko.
Yes.
And then, secondly, that particular night, the people in this house number 13511 Kutanan Street, Zamo section, Fosloras, they didn't sleep over at Mr. Twala's house. Instead, they went to sleep at Malbatten. That is the townhouse where Ms. Kelly Kumalo and the late Mr. Senzo Meyiwa were staying. It's in Malbatten, south of Johannesburg. Yes.
Do you have any comment about that?
No, my lord.
Cha ngikho ngaphawula mayelana nalendlu le yase Alberton.
Thank you, Ross. Were you aware that outside case number Phosphorus case 636-10-2014, whereby you came here as a witness, there is other case pertaining to this same matter, which is Phosphorus case 371-01-2019, opened by Warrant Officer Makubu and Lieutenant Colonel Telezi, pertaining the same incident, whereby among the charges is still the same, the murder, and they added the defeating the ends of justice in relation to the alleged tampering of the scene at that address. Were you aware?
I was not aware, my lord.
Cha benganalwazi lokuthi likhona lenye icala elavulwa elihambisana lona leli elavulwa nguwarrant officer Makubu kanye naye uButhelezi. I-case number yakhona le 837101-2019 kodwa lelo likhuluma nge-defeating the ends of justice benganalwazi nalokho.
In this case, the suspect charge would be the people who were in that house and who saw Senzo when he got injury that he got until he succumbed to the same injury at hospital. You were not aware that people have been charged. I mean, they've been, this case will be pertaining to those people in that house.
No, I was not aware, my lord.
Kana lapho benganolwazi ukuthi leli cala leli belizobandakanya bona labantu ebaphakathi kwayo le ndlu le ngalesikhathi leso abekwa bakwazi ukubona ngesikhathi kwenzeka lesi sehlakalo ngesikhathi yena ke umufa adutshula kufikela lokho asika azophangalana.
Your Lordship, I've got the document of arraignment of 7 people who were at the house number 13511, Kutanan Street, Muzamo section, Fusloras. It was arraignment. With the 5 charges.
My Lord, I think it will be improper to hand it up as my learned friend is trying to do. I think if they want to hand it up, they should perhaps call a witness to do that. Ma got information that it was just a mere draft that never saw the light of day, my Lord.
Are you going to call a witness about that?
There will be a witness who are investigating the same case, my Lordship. Yes.
There you are, advocate. He says he'll be calling a witness.
As indicated, my Lord, this was a mere draft. I don't know whether it's proper to hand a draft document that was still being considered and not in a final form. If the agreement is that it's just a mere draft, then and I'm not sure what evidential value it will have, but yeah, it was still in an inchoate state or still in inception stage, but that was never finalized.
My Lord, this is a document coming from the file of that case number 375, for which we did request as a disclosure. It was given to us as a disclosure, part of disclosure, for which I strongly believe, and I'm aware, that the state is also in possession of the same document or the case number, the case in this matter. So this is a document from the state, and it's disingenuous of my learned colleague, Advocate Valoy, to say want to give the evidence from the bar, say is still being considered by who, for what reason? Because this is case on its own, independent. It had its own prosecutor, its own investigators, and their own suspects, which unfortunately maybe for the state in this regard, it will somehow affect, would be the witnesses of the state, in this case, 636. So there is, because I don't want to also find myself guilty of what I'm managing to say, given the evidence from the bar. But now, I just wanted to introduce this document, which I believe has got a value. And then nothing more I should say, Your Lordship, is relevant, this document.
My Lord, it can go in as a draft for whatever it's worth, but my learned friend, just to correct him, the state never disclosed the docket that is just referred to, my Lord. And he knows what the circumstances are. It was given to him by Lieutenant Colonel Butelezi, not the prosecution. But my Lord, those are issues that we don't want to burden the court with. The document can go in as just a draft for what is worth. Hopefully evidence, as promised, will be presented at a later stage.
Thank you, Nurse. I just wanted to hand this for court.
I think, my Lord, the last document was, we can make it Exhibit C. So that no copies have been provided to any of the parties in court. We hope that in due course we will get a copy of that document.
Yes. By agreement, Exhibit C is admitted into the record of the proceedings of this case.
As it please the court, Your Lordship.
Yes?
I don't have other one for the witness, Your Lordship. May I ask my learned colleague, Advocate Valoy, just to... Oh, sorry. I've got the other ones. Thank you, my lord. So, oh, you still need a chance to go.
Continue, my lord.
Continue.
Yes,
Thank you.
ma'am.
Yes.
This document, Mr. Musia, is handed to the court and also to your attention in confirmation of what I put it to you, that other investigating officer of the same matter, they have found that the scene was tampered with, and they continue to open the case of the 15th ends of justice against everyone in that house.
My Lord, we are once again where we started this morning, that statements are put as facts to a witness. We just indicated this was just a mere, Exhibit C was just a mere draft that never went out. And now it's been put as a fact to a witness. We submitted that that question should be disallowed. And in any case, the witness cannot prefer a comment on something that he's got no knowledge of, my lord.
Who found Advocate Tefo? He said it was found that the scene was tampered with.
The investigating officers of this case, that they will be called.
So on what basis do you call it a finding?
Finding.
Because even in this case, investigators got busy. They did get information. Can we call that a finding?
There are five charges that the count here. Among them, the 15th end of justice in relation to the tampering or the cleaning of the scene.
I'm pursuing the word find.
Yes, for finding, my lordship, let me find the relevant word. As they were now assigned to investigate this matter, in their investigation and in their discretion, according to them, is their realization that this sin was tampered with. So that's when they come to the conclusion that they should add the charge of, they should add the charge of defeating the ends of justice. That's what I was referring to when I say fine.
As a court, please, my lord, if I can make a suggestion that my learned friend hold off on this document, and if he intends to call those two police officers, Buthelezi and Makubu, then perhaps at that stage he can then hand up this document, because those, according to my learned friend, those are the people, you know, with the knowledge of the document, but this witness cannot be of any assistance, my lord.
Not unless he is insinuating that this witness knows
Yes.
about that, because by the time those witnesses are called, Sergeant Musia will no longer be in the dock.
Yeah, I think the witness has already testified that he's not aware of this docket.
Okay. Advocate, therefore, he has already said that he doesn't know about this other charge.
The witness here, ma'am.
Yes.
I did hear his answer, but the reason I am introducing this document now, like the court has indicated, we were on the point of the tampering of the scene, which is very serious, and we are bringing a very serious allegation in that regard. So, hence, we have to, before you can stand down or before you can step out of the box, having the knowledge of this, because we don't want to later, it was never brought to the attention of this witness, because this witness is a crucial witness insofar as the security of the scene is concerned. So we find him very much relevant. So to know about that.
Yeah, his answer is doesn't know about it.
Irrespective of lack of his knowledge about that, is the reason that we introduced this. Now he knows.
No, you have already introduced. I asked him to comment. He says he doesn't know.
Yes. Yeah, look, I've heard that, Your Lordship. We bring this for the purpose of, let me remind this Honorable Court that I did indicate that in this matter, there is another case docket, which I knew and I suspected that the state wouldn't want this court to be aware of this case. And
I'm not questioning that you brought it up. I'm saying he has responded. Regarding this document, he has responded. Do you have another question to him regarding it or any other issue?
or to proceed, ma'am? Yes, I need to proceed. Actually, it was in relation to say to him, as the court is aware of the fact that the issue of his arrival at the scene, as also his observation was requested by the defense to give us how he analyzed the situation. What can you say about the scene of crime there? Whereby he denied that there was a tampering before he arrived, for which is a contention of the defense that there was a tampering. He was oblivious to the fact that there was a tampering at the scene of crime. Hence, this document that we are now introducing is supporting our submission to this witness.
And what is the question to him?
Yes, the question was that one. Say, were you aware of that? He said no.
Yeah.
Yeah, then I
mean
think
the following question about it.
Okay. The following question, Mr. Musia. Yourself as an expert, we don't believe that you can allow anyone to tell you what to do, what to take from the scene, including the members of the family, as you claim that other than information you got from Brigadier Ndlovu, you got this information from the member of the family that the crutch that you left You didn't take it for the ballistic, for the forensic. You didn't see the need.
It's correct.
Kuyiqiniso ukuthi ngikhulume kanjalo ukuthi le nduku yokuhamba ngiyithole lapha azange ngibone ukuthi kusikhona isizathu esingenza ukuthi ngiyithathe ngiyise ku forensic.
As we put it to you that, as we did put it to you that there was indeed tampering with the seal. Can I proceed?
Yes, proceed.
The document that just handed in as Title C is confirming our submission to this court, Mr. Msia. What are you saying?
No comment, my lord, on that.
Akukho engakuphawula mayelana lokho ucitha ukusho ukuthi leli phepha leli ucitha ulifaka la enkantolo exhibit number C iqinisekisa iy'nsolo zenu.
Yes.
Thank you. My lord, further to that, yes, I will be wrapping up my cross-examination. Would like to further introduce or read for the record the statement of the leading investigating officer in this matter in relation also to the confirmation or that is contradicting the state case in terms of charge number from charge 1. This affidavit of the leading investigator, Brigadier Kininda, is so meticulous to extend that is contradicting the whole case of the state and to the benefit of our client. Insofar as the arrest was concerned. The statement is already on it's in one of the files, or not? It's the A225.
My lord, once again, there is a way of handing exhibits. You call a witness. You cannot just hand a statement from the bar. If they want to call that witness, by all means, they can hand that document via that witness. But, my lord, we object against the procedure that is being adopted by my learned friend at this stage. We urge him to follow the normal way of
I can't hear you.
we urge him to follow the normal way of proving a document. You call the person who drafted that document.
Advocate, therefore.
Those are the rules of documentary evidence.
Your Lordship, this is a document which has got the value and is the document that is brought here as the case of the state, and this witness is the witness of the state. So will be called by the state.
Listen,
then-
but he is objecting to the manner in which you are introducing the document. He's saying you should comply with rules pertaining to documentary evidence and how documentary evidence gets introduced into proceedings.
Actually, Your Lordship, it's not that I want to hand over this document. I want to read this document to the record, because this witness is still coming. And then this witness cannot stand down from the doc box or the witness box before can be aware of the contents of this. And we definitely, he will definitely have to comment about this.
When you read it into
And
the
I've
record,
got-
when you read it into the record, is that not as good as having handed it in? Is the court left any the poorer because it was read into the record instead of being handed in?
Reading into the record, my lord, is not like handing, because as I said, it's not a witness of the defense. It's a witness of the state. And the whole cross-examination and the answer also responded to by the witness, they are definitely within the jurisdiction of this affidavit. Hence, I say it will be prudent for this document to be read on record in the presence of this witness, and there will be a question of cross-examination that will be coming in and expecting the response from the witness.
Advocate, Maloy.
My Lord, as the court pointed out, once the contents of the document are referred to, it's as good as having accepted the document has been proven. And my Lord, we contend that my learned friend should hold off on the document until this witness is called. In any case, my Lord, this witness cannot proffer any comment on the document. In any case, should the need arise, this witness can always be recalled. But at this stage, my Lord, we object to the handing in of a document which hasn't been
No,
proven.
it's
in-
no longer
in
on
the-
handing in the document, it's now on reading the content.
Yes, but it's 1/6 of one and half dozen of the other.
Yeah.
You know, once you read the contents, then it means the document has been proven, to which we object, my Lord.
I think if needs be, that this witness will be recalled instead of us ignoring proper procedure of introducing this evidence.
Your Lordship, it's more of, okay, let me be specific. It's more of the, like I said, it's more of charge number 4 to 5, the caliber of the firearm that was brought at the scene of crime.
But you are introducing evidence wrongly. It has been said many times here that you will need to call witnesses to that, and you seem to say you do have those witnesses. You haven't as yet called the witnesses, and therefore you cannot bring in the evidence that they will be testifying about. And since you are worried that you want this to be bounced at this witness, we are saying if needs be, then that this witness will be recalled. We cannot ignore the proper way, the proper procedure of introducing evidence because he is about to finish and go. He will be available. So let us be compliant. Let us not create procedures of our own when we know there are procedures that are laid down for every process in a trial.
It's fine, my Lord, but I was trying to make sure that I don't want to cause this witness to come again.
Yeah,
here.
you were trying, we saw, we appreciate it, but then
All right.
you didn't succeed.
All right, before I continue or I finalize my Cross-examination, Your Lordship. My learned colleague, my attorney, need to address this court. Something very urgent, very dangerous to the safety of the witnesses of the defense, 1 to 4, and the defense themselves. The advocate's life is at stake here. The attorney's life is at stake here.
Are we not rounding up this witness? Does this witness have to stay for that?
No, this is very important to be addressed first before I
By
finish.
this witness?
Yeah, witness has to be there. Then my attorney address the court.
I don't understand. I don't understand.
Sorry, my lord, sorry to interrupt. I really apologize. The witness, as the state mentioned, he can be recalled anytime. The problem here, since the watching brief was removed from this matter, I received funny calls. I received threat. Your Worship has
That can,
my lord.
that can come once we excuse this witness.
We are not done with the witness because there's other questions we want to prepare to ask the witness. Since the court and the since the state objected to this question, we need to rephrase this question in a correct manner. However, this cannot wait. It's very urgent.
Advocate Baloyi, they want to address about the safety of witnesses. They want to do it now. Why is this witnesses?
Well, I suppose if there was any threat imminent or impending, the IO would have brought that to our attention, and they haven't done so as yet, my lord. I've got no idea what my learned friends here are referring to or what they want to do, my lord.
My lord, the investigating officer won't know about this because he's the investigating officer, is a witness to the state. Can you imagine while you are at home, someone calls you, asks you if you know a particular acting judge. Then if you ask that person, why you ask me this question? Then he drops the phone. The next thing he calls again, then I can hear paperwork on the table, doesn't say anything. In one day, I'll receive 5 calls. Today, during lunch, we had a tip that they want to arrest my advocate, my lord. That's the intimidation tactics. And my lord, we are not going to proceed today. Since the court might have been aware that after lunch, it seems as if my advocate is being disturbed. My lord, he is not in a good mind as it stands now, after the information we received. And there's no way we'll proceed under these circumstances. That's the violation of the Constitution. Yesterday, we were celebrating that Constitution. They call it Freedom Day. Now, today, we are experiencing this. With due respect, my lord, we are not in a position to proceed today. Let's say, for in case they indeed arrest my advocate, and the death threats still continue, funny calls still continue. We don't need the protection from the state. We don't need it. The state can have the protection. The state personnel can have the protection. Maybe they also assist the court with the protection. But as for us, we don't need it. Because remember, we are the defense team. It don't assist us in any way. Once we do that, it will give some of them in the state our whereabouts. So we don't need it. What I'm asking here today, my advocate is not in a good mind to proceed after what we received during lunch. As the state said, the witness in the box can be called anytime. We have resources, my lord. I appreciate for my Lord to give me an opportunity to highlight this to the court. Thank you, Your Worship.
Advocate Baloyi.
Well, let us see. In any case, it's towards the normal day of the normal time of adjourning. We can perhaps. In any case, it appears that we won't finish with this witness. Advocate Mshalole indicated that she'd prefer to start when we next resume. So we suggest that maybe we adjourn at this stage. A date has been arranged. It's the 30th of May for the continuation of the proceedings. And the case will be set down from the 30th of May until the 15th of June, my lord. And the accused are in custody at the respective detention centers.
As the court pleases, my lord, I've got a special request before we adjourn this matter, my lord. I have discussed it with my learned friend for the state that I'm asking my lord on the next appearance that the witness who is in the witness box brings the electronic photos, the laptop, and the projector so that I'll be able to use those facilities when I'm cross-examining, my lord. I've discussed it with my learned friend. I'm just putting it on record, my lord, so that the court will know that when I'm doing cross-examination, we'll be using the projector and the electronic photos, not the hard copies, as the court pleases, my lord.
Advocate Baloyi.
Indeed, it has been discussed, my lord, and we have made tentative arrangements in that regard, my lord.
Electronic photos, a projector, and what?
Sorry, my lord. Electronic photos, my lord. The laptop.
Yes.
And the projector, my lord. It will also maybe assist the defense team, my lord, also to have disk or memory stick so that we can also be able to put it in our laptops. So that when we are beaming the pictures, my lord, we are all able to follow.
Ummeli wakho mangana isihlalo ne uthi uqala kakhulu ke ukhulume nomshushisi ukuthi ke njengoba leqala lizohlehla liso lemuva uma sibiya sidibana la makube khona ke lokho sikubiza ukuthi ma electronic or ama digital photos azosetshenziswa kuleqala kube khona i-laptop kube khona futhi ne-projector futhi uqala ukuthi kube khona ne-memory stick le nayo azokwazi ukuthi ayisebenzise ayifake ku-laptop yakho ukuthi makabuza imibuzo konke lokho kuzoqhamuke lapha ekondeni ngiyangizwisisa ngisho kuzoba nesikhlinyana esincane esimhlophe lapha then esizosebenza kubonakala yonke into emibona ningizwile ngisho bafethu.
That, my lord, will shorten the time of cross-examination instead of going through the hard copies, my lord, as the court pleases.
Seningasukuma manje bafethu izohlehlisa isikhala ngiyasukuma.
By agreement, this case is postponed for further hearing to the 30th of May 2022 with the accused in custody. It is agreed among the parties that for purposes of the proceedings and with specific reference to cross-examination by Advocate Michololo, the current witness, Sergeant Musia, shall avail electronic photos, a projector, and a laptop. It is also suggested that a memory stick be also used so that all parties get to have the material within their respective laptops. So the case is postponed to the 30th of May with the accused in custody. It's postponed for further hearing. And Sergeant Musia, I take it you don't need a lecture about how to behave when you are still on the dock. You are not excused. You are still a witness in the dock regarding this case, around discussing this case with anyone in any manner, whether by phone or whatever other means.
Yes.
Standing off, rise and cross and around. Got a second, yeah. Hey, Michael. Stand up.